Good morning, everyone. Just before we start, can I just deal with a couple of things? First, Mr. Rowe, you'll remember on Monday we had a discussion about Section 16 of the Evidence Act and the compellability of witnesses, in particular the Speaker. Under Section 15 of the Commission of Inquiries Act, for a witness not to comply with a summons is a criminal offence. But under Section 16 of the Evidence Act, in certain limited circumstances, the Legislative Council, now the House of Assembly, have set out circumstances in which someone, such as a House of Assembly member, need not comply with a summons. They're very limited. We discussed that. We agreed that on Monday, the scope of Section 16, the Speaker did not fall within it, because the scope of it is a member of the House of Assembly need not comply with a summons if there's a sitting of the House or a sitting of a committee of the House, and those did not apply to the Speaker on Monday. But helpfully, on instructions, you confirmed that Friday of this week would be convenient for the Speaker, and it was fixed that he should honour his summons at 12 noon on Friday. And in the published schedule, that is when he's due to be heard. At 3 minutes to 11 last night, we had the COI Secretary had an email from your partner, Mr. Fliggleston Davis, as follows. Dear Mr. Chandler, please see below for email. And then there's a quoted email coming apparently from the Speaker to you. Silk legal to date, I'm not aware of when I have to appear before the Commission of Inquiry, as I have not, that word is in capitals, seen anything in writing from you, nor a summons from the COI after indicating I was available on Monday, the 14th of June, 2021 at 1:30 p.m. However, I will make myself available on Monday, June 21st, 2021 at 1 p.m. I am very busy with House of Assembly matters, as we have another sitting on Thursday, the 17th of June, 2021. Please convey to the Commissioner that I will be on standby for Monday, and when they are ready for me, I will arrive. However, I will not be sitting in a waiting room for hours. Please confirm when this has been conveyed to the COI and send me a copy of whatever paper you will be required to file on my behalf to give effect to this request. That's the end of the quotation, and indeed the end of the email that you sent the COI Secretary. I mean, what one's tempted to ask Mr. Rowe what is going on, but it's unnecessary, I think, for me to do that. I'd just like you to confirm that the Speaker will be here to honour his summons at noon on Friday.
Attorneys are creatures of their instructions, Commissioner. I can only advise, and having also of the consequences of not taking the advice regarding to the sections you have raised.
Well, just one moment. From this email, which appears to emanate from the Speaker to you, he seems not to know that he's due here at 12 noon on Friday.
That's not the case.
Good. So he knows that that's when he needs to comply with his summons.
He knows.
So why were we sent this email?
We sent this email because we were instructed by our clients to do that.
Right.
You'll appreciate, with many years like myself, with these gray hairs, one's instructions can either be accepted in full, rejected in full, or in part.
So when this email was sent to you, the Speaker was aware that he is due to comply with his summons at 12 noon on Friday, although he says that he had not seen anything in writing from you.
There's nothing in writing because the communications are oral.
Well, what you said to your client, of course, is privileged. But in any event, he knows. There are no issues about service of the summons. There are no issues about service of notice of when he is due to come, because we have told his legal representatives, and that is sufficient. So you accept that we have done everything that we need to do?
It might help, given the consequences, if a direct summons to him were sent again. It would help in terms of if it is not too inconvenient.
Well, it's unnecessary because he's got the summons. And you have told him, you can put that in writing to him. I just want to make absolutely sure that there is nothing else we should do, in your view, to make him legally compellable. It's important because if he doesn't turn up on a summons when he's due to turn up, that's a criminal offence.
Indeed. He's been so informed, my lord. He's
been informed. Anything you want to add, Mr. Rowett?
Nothing, thank you, Commissioner.
Okay. Thank you, Mr. Rowe. Can I just raise one other smaller point, but an important one? Under the rules and the protocols, everyone participating in a hearing is asked to come here 20 minutes before we start. That's because we have to set up the technology and set up the hearing room, and we want to start on time because we have so much business to get through. So could I just politely remind everybody to turn up in good time so that we can start on time. Thank you all very much. Mr. Rowett.
Thank you. Commissioner, before I call our first witness of today, can I just, for the record, introduce the representation?
Yes.
On behalf of the Attorney General, we have here today the Solicitor General Joanne Williams-Roberts, and on behalf of 7 elected members of the 7 members of the House of Assembly, which includes the speakers, we have Mr. Richard Rowe of Silk Legal. Our first witness this morning is the Honourable Julian Fraser. As you'll remember, on Monday, Mr. Fraser was sworn because he gave brief evidence about his availability, and so there's no need to swear him in again.
No. Mr. Ray, you're still bound by your oath or affirmation?
Sure do.
Yes, thank you very much. Yes.
So if I can continue, first of all, Mr. Fraser, can I thank you for returning to give evidence today? There's no need for me now to ask for you to put your full name into the record or indeed your professional address. What I will tell you is this, that as we go through, I strive to keep my questions short and simple. But if at any time I put a question to you that is difficult to understand, please do ask me and I'll rephrase it or repeat it in a different way. There are a number of bundles in front of you. We will, as we go through, go to different documents in the bundles, but you don't need to look at them now. Could I also just finally ask you to keep your voice up and speak slowly? And the reason for that is because, as you'll be aware, a transcript is being made of this hearing, and it's important to record your answers as clearly and accurately as possible. Can I start, as I have done with every witness so far who has come to give evidence to the Commissioner, and that is by asking you to give an outline of your professional background before you entered politics.
I am a registered architect in the state of New York and the United States Virgin Islands. I practiced architecture in the city of New York until 1993 when I came to the BVI, and there I practiced architecture until I entered into politics, or got elected, I should say, in 1999.
If I pick it up on that last answer, in 1999, that was the first time you were elected as a member to the House of Assembly. So
yes, it was.
It would have been at that time the Legislative Council?
At that time, yes.
And that was, that was for the Virgin Islands Party, is that right?
That's right.
And you were elected to represent the 3rd District?
That's right.
And you have represented the 3rd District since that time?
Yes, I did.
Is it right that between 1999 and 2003, you held ministerial office?
Yes.
I think, first of all, you were the Minister for Natural Resources and Labour, and then you were subsequently appointed Deputy Chief Minister and Minister for Communications and Works.
That's correct.
And then between 2003 and 2007, you were in opposition.
Yes.
And then in between 2007 and 2011, your party returned to government, and in that time you were again the Minister for Communications and Works. Is
Yes.
that right? And then the party once again went into opposition thereafter, but you ultimately led them into the general elections of 2015.
That's correct.
And then became the leader of the opposition until 2017.
That's correct.
And you then subsequently formed a new political party, is that right, called Progressives United?
That's correct.
And you contested the 2019 election and were again elected
Yes.
to the House of Assembly. Now, in the 3rd District, at present, how many people live in 3rd District?
Approximately 3,000, which is same for all districts, basically.
I was going to ask for your assistance for that, because the Honourable Vincent Wheatley gave evidence yesterday afternoon, and he said that there are boundary arrangements and rearrangements from time to time that seek to ensure that the population of each district is approximately the same.
That's correct.
Would you agree with that?
That's correct.
Of the approximate number of, which I think you gave us 3,500 who live in your district, how many are eligible to vote?
About 1,600.
The official results as published on the government of the BVI's website records that in 2019, 1,102 votes were cast in the 3rd District, and you received 519, which was 47.10% of the total vote. Your closest opponent then receiving 294 votes, which was 26.68%. Does that accord with your recollection of the outcome of the 2019 election?
It does.
One of the points, and you may or may not have picked up on this, but one of the points that I have been asking members of the House of Assembly about is making the register of interests available to the public for inspection. And I've been asking for their views about the benefits of such a step. What is your view on publication of the register?
It depends. I can't give you my views on that until I see the details.
But in principle, do you have a view? Do you think that it would be a good idea for the public to be able to inspect the register?
It's something that I'm prepared to look at. If we have the benefit when we're making laws to debate the bill before we sign off on it, and in the debate, all these things come out. It may not be something that I can latch on to wholeheartedly. If the merits warrant my support, I'll give it.
That it is, and there is a Register of Interests Bill 2021 in the offing.
Is that right?
Well, that was the evidence of the Attorney General. The evidence that the Attorney General gave was that the bill is still in the drafting stage. It has not yet reached Cabinet, and it hasn't therefore not yet reached the House of Assembly. The part of the evidence of the Attorney General was to confirm that there is a clause in the bill that would make the Register of Interests available to the public. And against that background, what I'd like to ask you is whether you are aware that whether there have been initiatives in the past from various legislators to make the Register of Interest public.
No, I never heard it before, and that's a flaw in the system because there's no consultation. We're in the House of Assembly, and I have to come here to learn that there's a bill coming before the House with such proposals, and then you expect me to support it.
I'm not asking you whether you're going to support that bill or not.
You asked me if I'm going to support the principle.
Yes.
You should have told me about it before.
Well,
this is so huge. It needs discussion.
My question was whether, to your knowledge, being a legislator who has represented the 3rd District since 1999, you were aware of previous initiatives from either members of the House of Assembly, or it would be from members of the House of Assembly, to make the register of interest public?
Never.
Never. Have you ever spoken publicly, either in support or against a measure to make the register of interest public?
I never discussed it.
Could I ask you, I hope you will have in front of you a bundle which is headed Constitution and Legislation bundle.
Commissioner, if I may.
Yes.
I understood that, first of all, I was asked to submit documents to you, which I did. And particularly speaking about the register of interest and declaration of interest. The law was changed that gave the commissioner of inquiry access to the information in the register. I presume that you have all that information. My question would be, why am I here answering question about this issue? Well, if you have the information, I don't know, I'm just asking.
Well, firstly, to confirm that the information we have got is the correct information that you've lodged with a number of witnesses. The information that we've been provided by the registrar is not complete. We have been told in oral evidence. And also, I'm particularly concerned about not simply whether individual members of the House of Assembly have complied, but the system, whether the system works. In the system, I mean, do people comply with their statutory obligations? In terms of the form, do they all understand what their obligations are? Is their understanding the same? The evidence we've had to date is that understanding of the form differs very much as between individual members of the House. So I'm looking in particular at the system because I'm interested at the moment in governance.
The other question I would like to ask, Commissioner, is I understand that my attorney is not allowed to cross-examine me.
Well, an attorney can't cross-examine his own client, but in any event, this is not a trial. This is an investigatory process, an inquiry in which I'm trying to obtain information. So it's really the commissioner who asks the questions, usually through counsel to the inquiry. If Mr. Rowe thinks that there are matters that should be put to you which have not been put to you, then under the Commission of Inquiry rules, there is a process for dealing with that. Mr. Rowe, who has the rules, will know what that is, but it's effectively to raise any further questions with me, either through counsel or directly.
So as it is for this particular sitting that I'm in right now, I'm allowed to defend myself.
Against what? There are no allegations being made.
Well, if I want to enter something into the record, if I want to answer a question that's given that requires reference to something, a particular article of law or something to that effect.
Well, if it's law, then obviously Mr. Rowe will help us with that. But I don't think there's any particular point of law at issue. I don't think that, well, we'll have to see what you say in regard to your obligations, but the Act in terms of obligations is very clear, I think. No witness so far has suggested that those obligations are not clear.
Yeah, Commissioner, no witness so far.
Yes.
But I am not any witness.
No, you may say that the obligations are not clear, and that
right.
That would then be your evidence.
And I think that each witness will be different, unless, you know, I expect each witness to be different. Yes. I think I will be different.
No, the evidence of each witness is of course different. In particular, in relation to understanding various parts of the form, their evidence has differed. But what I suggest is that Mr. Bilal Rawat will ask you some questions. If you have any issues in relation to any of the questions, raise those with me.
Good. That's just basically what I wanted to know.
No, certainly, yes.
Thank you so much.
What I would...
Just before we proceed, sir, is it still my understanding that we will be having discussions on our submissions on Friday?
Well, almost. What I said was, Mr. Rowe, is that I'd hear submissions on criticisms is perhaps the best word to use, any criticisms of any particular witnesses at the end of this topic. The end of this topic now, of course, will be on Monday, but not on Friday. But otherwise, that's
on Friday. As you will notice, Commissioner, that our position is that the summon rules are not just suggestions, but are binding law. This is our submission.
No, I understand what that submission is, but and I don't want to interrupt the evidence unnecessarily.
No, that's what I wanted to do this now.
But at the moment, and you've seen some of the witnesses, and the evidence of the others is either available on YouTube or the transcript.
Indeed.
But I'm looking at the moment at the system for registration of interests. All of the witnesses, bar two, to my recollection, I'll be corrected if I'm wrong, have accepted that they have been in breach of Section 3 of the Register of Interests Act, and indeed in some of them in breach of Section 7. Whether it's necessary to write to them or you about those admitted breaches is something that we can discuss on Monday.
Indeed,
but they've simply accepted it. There's no sort of mystery or doubt about it. But I will hear submissions on that.
There's no doubt, sir. You made it lucidly clear that the process still is investigatory.
Yes.
There's no accusatory aspect to it.
No,
so that is we understand.
But the witnesses have frankly and openly accepted that they're in breach.
Indeed.
But I'll deal with how we deal with that on Monday.
On Monday. I appreciate that.
Thank you very much, Mr. Ray.
Thank you,
Rawat.
Thank you.
You understand? Sure. So there's no accusation.
If you could, I think you've got open in front of you, Mr. Fraser, the bundle that is relates to you, but there should also be on the table a bundle that is headed Constitution and Legislation bundle.
Yes.
And perhaps if we start off with that bundle so that we can see the context in which
may I have a copy of that
questions.
There's none here. There are two bundles for Withers.
The Constitution Legislation bundle and also the policy bundle were issued by the COI, I think over the weekend, with the direction that they would only be available in electronic form. And that advocates, if they need to, should bring their own copy. So I don't think we would have prepared a copy for any advocate in the room.
I think in our consultation with Withers, we were informed by them that they were delivered certain documents. We have not been received.
No. Mr. Rawat is right in relation to this bundle as I understand it. And again, I'll be corrected by someone if I say anything wrong. Withers asked for the individual bundles for their witnesses for Monday, and they were provided with those over the weekend.
We received those.
Yes.
We received those. But this is it seems to be a new bundle.
It was a bundle that was emailed out over the weekend. And it was emailed, I'm sorry to cross you.
No, sorry.
It was emailed to all the legal representatives of the participants with two messages. Firstly, that it might be added to from time to time, but secondly, that it would only be retained in electronic form. And so if any legal representative wanted to have a hard
Have a copy,
copy,
he make
it's
his own.
for them to print it off themselves. Now,
I will have to check it out, Secretary, why it wasn't provided to me.
I mean, Mr. Rowe, I suspect that Mr. Rowett will be referring to very few provisions in this bundle. And I
yes,
suspect that they'll be fairly short provisions.
Indeed.
and ones with which Mr. Rowe will be familiar.
He'll be very familiar from the previous witnesses.
Yes.
Certainly.
But I wanted just to assist Mr. Fraser by
Mm.
giving him some context. Mr. Fraser, if we could go to page 59 in the bundle.
No.
This is the first page of the Register of Interest Act 2006. And that came into force on the 18th of February 2008. And it is the current law that relates to the Register of Interests. And it's the law that relates to members of the House of Assembly making declarations of interests. It has, just to assist you, been amended twice, once in 2007 to change references to the Legislative Council to the House of Assembly. And the second.
Can I actually say it came into force in 2008,
Yes, 18th of February 2008.
but it was amended in 2007?
Yes.
I
I can show you the amending act.
It had to,
The act was amended before it came into force.
Yes.
Mainly, Mr. Fraser, to take into account the changes in the Constitution, in particular the change of name of the Legislative Council to the House of Assembly.
that I understand, but it couldn't have been an act if it didn't come into force.
Well,
It must have been a bill.
Must have been a bill.
it is perhaps one of the sort of outstanding questions about
Title is wrong.
about the way that legislation is drafted in the BVI, because sometimes a bill is referred to an act, and I can show you an immediate example of that if you wish, but it's accepted that it applies to the House of Assembly.
The title is wrong. That's what it is. Title is incorrect. It couldn't have been an act of 2006. It was passed in 2008.
No. Well, again, Mr. Rowett will correct me if I'm wrong. It was passed in 2006, but it didn't come into force. As you know, statutes can be passed and not come into force. Before it came into force in February 2008, it was amended. That's not unusual, Mr. Fraser.
Okay, so it was
an act.
It was assented to for 2008. It became an act in 2008.
It was again
came into force.
Yeah,
it began to apply as a piece of law in 2008.
But the assent was in 2006.
Okay.
So the act is the Register of Interest Act 2006, but it came into force in February 2008.
A more recent amendment, which you will be aware of, is the 2021 amendment that came before the House of Assembly, and that was to amend the Act so that a Commission of Inquiry could receive information from the Registrar of Interests. If I take you just to page 61, please. Section 3 at the bottom of the page records section 3.1. A member shall make a declaration.
Page 61?
61, yes.
Okay, good.
A member shall make a declaration in the form set out in Schedule 1 within 30 days after this act comes into force, and thereafter on the date on which he assumes the function of his office and on each subsequent anniversary of that date. Subsection 2A reads, a declaration of interest under this section shall be made in respect of interest held on the date on which the duty to make the declaration arose. So bringing that to the modern day, there is an obligation on members of the House of Assembly on the day that they are sworn into the House to make a declaration under this act, and then on the anniversary of that date thereafter. If you go, please, to section 7.
So the first declaration would have been in 2011.
Yes, but the first declaration would have been within 30 days of 18th February 2008. But
The declaration is to be made when the act come into force or when you get elected.
if you look at section 3.1, it says within 30 days after this act comes into force.
Okay.
But thereafter, and other members of the House of Assembly have accepted this, when on the day you are sworn into the House of Assembly, that's when the duty arises.
Okay.
And that date will change depending with each new House of Assembly. If you go to section 7 at 64, I just want to draw your attention to section 7A. Where a member fails to make a declaration within a period of 3 months from the date on which the duty to make that declaration accrued, and it then continue at the bottom, the member shall be in breach of the provisions of this act, and the registrar shall, within 14 days of the knowledge of such breach, submit a report of such breach to the committee, which shall meet to consider the report within 21 days of its submission. The reference to the committee is explained in the interpretation section of the Act, which is at page 60. Committee means the Standing Select Committee of the, and that should be House of Assembly, charged for the time being with the consideration of matters relating to the register. And so there is a second way in which a breach can arise for a member. If 3 months after the date on which you are supposed to file your declaration, you still haven't, that is a second breach, and the registrar has to send a report to the Standing Select Committee. Now, this Standing Select Committee would have come into force at some time from 2008, and it would be reconstituted for each new House of Assembly. Have you ever been a member of the Standing Committee in your time as a member of the House of Assembly?
Yes.
In which session of the House of Assembly were you a member of the committee?
In the third House of Assembly.
And that ran from, what were the dates of the third House of Assembly?
2017 to 2019.
In that,
and may I add that that was the first committee for the register of interest. There was never one before.
So in previous Houses of Assembly, that none had been set up?
It couldn't be because the standing orders didn't provide for it.
Thank you for that.
So there was an amendment in 2007 making it possible to form a committee.
Can you remember when in 2017 that was established?
I can't tell you the date. I'm sorry.
So sometime in 2017, the standing orders were amended to allow for the establishment of the Standing Select Committee.
Yes.
Once it was established and you became a member, could you just clarify what was your role on the committee?
Well, once a chairman calls a meeting and it convenes, we had one meeting in the Registrar General's office and the Register of Interest office or the Registrar's office. And the report before us at the time was dealt with. Don't ask me what it was at this stage. It's a little while since then. We had this catastrophe, you remember, it caused a lot of memories to lapse. But it was after the hurricane, just in the period just after the hurricane, we had a meeting.
And during your tenure in the House of Assembly, that was the only meeting of the committee. Only meeting. And at that time, you were in opposition, is that right? In
Yes.
2017 to 19. And subsequent to that, in this House of Assembly, you've not been appointed to the Standing Select Committee?
No, not.
Could I ask you, obviously, because you have been a long-standing member of the House of Assembly, you have a number of declarations, but you have been consistent in terms of the details that you have provided. I'd like to therefore just take you to one example of the form which you completed to ask you questions about your approach to the form. And if you go back to your bundle, please. If you could go, please, to page 142.
System. Yes, I'm there. 142.
This is the declaration, Mr. Fraser, that you made for 2021. There's a stamp at the top of the page. It's the stamp of the Registrar of Interest. In manuscript is written the date, 26th of May, 2021. If we want to just perhaps deal with this quickly.
May 26th.
26th of May, 2021. But if you look at page 149, can you confirm that that's your signature on that page?
Certainly is.
And it carries the date March 12th, 2021.
Yes, it does.
If we go back to page 142, please.
142.
Yes. And as I've said, the form reflects your answers consistently, not given different information from one form to the other. The first paragraph of the form requires a member of the House of Assembly, or asks a member of the House of Assembly, do you have any remunerated or unremunerated directorships in any company? And you've answered no to that. That's the position, is it, for you?
It's when you're looking at the one that's from the registrar.
Yes.
The first question you're looking at?
Yes.
Yes. No.
So
My answer is no, just as it states there.
yeah. Now, do you, in your approach to this question, and the reason I ask it is because different members of the House of Assembly have taken it to mean different things. But what did you take the question to mean?
Exactly what it says.
So
Yeah, you have to bear with me in the fact that I was there when this law was made. I have no excuse for being ignorant to the law. It says exactly what it says. So you have remunerated, unremunerated directorship. The answer is no.
if you then go to page 143.
Yes.
Remunerated employment, office, profession, etc. And you're asked, as a member of the House of Assembly, do you have any employment, office, trade, profession, or vocation, apart from membership in the House of Assembly or ministerial office, from which you are remunerated or in which you have any pecuniary interest? And again, you've answered no to that, as you have on every declaration of interest.
Yes.
And so that's your position. So is your position that once you were elected as a legislator, you ceased, for example, to practice as an architect?
Yes.
Now, some members of the House of Assembly, in filling in this form, have taken this to be the place to disclose DBAs. Now, you've made the point that you were there when this law was made, and there's no excuse to be, as you said yourself, you have no excuse to be ignorant of the law. But from that position, would you agree that that is where you would expect such details to be given by a member of the House of Assembly?
I can't speak for other members of the House of Assembly. I can only speak for myself. The answer is straight. No interest.
The purpose, please finish.
Vocation, none whatsoever.
The reason for it wasn't asking you to either speak for individual members themselves, but because you, as you said yourself, you were there, and so you can assist the commissioner with insight into the purpose of this law, and in particular the purpose of this form. And from that unique position, perhaps, would you accept that if someone were wanting to declare a trade license or a DBA or any other kind of business, that's where you would expect it to be?
That's a good place to put it.
Now, at the bottom of that page is paragraph 3, which is refers to clients, and it asks, does any of the paid employment registered in categories 1 and 2 entail the provision to clients of services which depend essentially upon or arise out of your position as a member of the House of Assembly? And you're directed to the notes, which you'll see over leaf. And in particular, you're directed to note 1. Services covered by this category include action connected with any parliamentary proceeding, sponsoring meetings or functions in the House of Assembly building or offices, making representations to ministers, fellow members or public servants, accompanying delegations to ministers, and the provision of advice on parliamentary or public affairs. Now, again, you have answered no to that, as
Yes.
you have done throughout. So that's your position made clear.
Right.
But taking you back to that position of a person who was there when this became law, can you assist the Commissioner with what you understand to be the purpose of this paragraph?
It suggests that if you have any involvement with persons who assist you in any which way in your parliamentary duties, and you in return facilitate them with some form of favor, you're supposed to disclose that.
So if you're a director of the company and you facilitate access to a minister, for example, on behalf of a client, that's where that should be recorded. Would you accept that?
Right. If we don't have what you call lobbyists here, but if you were to get involved with the functions and duties of a lobbyist, and you were to take gifts or favors from that person in return for giving them access, this is where you expected to receive information.
And I'll come back to this question shortly, but if I take you then to the next paragraph, which you'll see at 144, and it's paragraph 4 of the form headed sponsorship. And it has 2 elements to it. The first is, did you benefit from any sponsorship before election, where to your knowledge the financial support in any case exceeded in aggregate $2,500? You've again answered no in every declaration of interest, but putting the question more widely, what do you understand is meant by sponsorship before election?
Any contribution someone made to you towards your election is a sponsorship.
So that includes a monetary donation. Would it include provision of services in your view?
Sure does.
What the member is also asked, and this is at B, do you benefit from any form of sponsorship, financial or material support as a member of the House of Assembly? And again, that's obviously, if is that intended to catch where once you're a serving member of the House of Assembly, you get any benefit from anyone, for example, subsidized accommodation, you should be declaring it there.
Yes.
I can take the next sections shortly. Paragraph 5 of the form, which you'll find at your page 145, Mr. Fraser,
Yes.
is headed Gifts, Benefits and Hospitality, Virgin Islands. It sets some threshold, but it is intended, isn't it, for a member to declare any gift or benefit or hospitality that meets those thresholds, but which they receive from a company, organization or person within the Virgin Islands. Would you agree with that?
I do.
6 at 146. Overseas visits. What the member of the House of Assembly is expected to declare is not personal trips that they may make, as any individual may make, but rather trips that they are making overseas as a member of the House of Assembly, but which they don't fund themselves or isn't funded by the public purse. That's the proper interpretation of this paragraph, isn't it?
That's it.
And then if we go to 7, and I should say for the record, in relation to both paragraph 5 and paragraph 6, you have indicated no, as you have done on every declaration.
Yes.
7 returns us to benefits and gifts, but it's overseas benefits and gifts. This is at your page 147. And again, there are thresholds set, but there the elected member of the House of Assembly is asked to declare any gift or benefit received from a foreign government, organization or person which in any way relates to your membership of the House of Assembly. Now, again, you said no to that, but that's again intended to catch hospitality that's given to you, for example,
Exactly.
as a member of the House of Assembly.
Exactly. If I can give you an example.
Yes, please.
One time I was traveled and I had a meal. And someone offered to pay for it. And I told him, you can't do that. You don't know where this is going to end up. I pay for my own meal. Simple as that was. So with this declaration of interest, you may not get the same answers that from others that you'll get from me, but I can tell you, I walked into this with my eyes wide open because like I said, this bill was created during my tenure, and I know what it's all about. I know to stay away from these things. When I got into politics, I discontinued my practice. I don't collect a dime for anything that I do. I don't do anything. So don't be surprised when you see these answers as no.
You've made the point that you said you walked into this with your eyes wide open.
Wide open.
Stepping back from the form, and you've filled it in a number of times. Do you think it's clear as to the purpose as to what it wants a member to declare?
I'm very clear about that. And I think the form is clear as well.
And you have, if we go to 8, which is at 147, where you have answered yes, it is to land. But the question that is asked of the member of the House of Assembly is this, isn't it? Do you have any land other than any home used solely for the personal residential purposes of you or your family? And so there is no obligation on you as a member of the House of Assembly to declare your own home, is there?
Right.
Its purpose is to identify if you have any other land interests. Is that right?
Right.
Now, you have declared ownership of 2 pieces of land. You said that you're an owner in common of a piece in Sea Cows Bay and another one in Chalwell Hannahs. And that's again what you have said throughout your declarations of interest. It has not changed.
Right.
Just so that we clear about your approach to the form, neither of these are your personal residential home.
No.
And again, when you approached the form, you didn't see any ambiguity in what you were being asked to disclose.
No.
If we go to shareholding, which is at 9, again, there are thresholds as to what the shareholdings that a member is obliged to disclose. But again, you've always answered no.
Right.
But returning again to your wider experience, is it your position that that is also clear about what it's seeking?
Exactly, it's clear.
Now, 10 is headed miscellaneous. It's on 148, and it says this: if bearing in mind the definition of purpose set out in the introduction to this form, you have any relevant interests which you consider should be disclosed, but which do not fall within the 9 categories set out above, please list them. If I just remind you what it says about the definition of purpose, you'll find that if we go back to page 142. And if I read that out, at least the definition, the main purpose of the Register of Interest is to provide information of any pecuniary interest or other material benefit which a member receives, which might reasonably be thought by others to influence his or her actions, speeches or votes in the House of Assembly, or actions taken in his or her capacity as a member. Now, before asking you a question about how you interpreted the operation of paragraph 10, what you disclosed was a condo jointly owned with your wife. Why was it that you put that, and if this is in New York, why was it that you put that under paragraph 10?
There was no other place to put it. It's not under shareholdings. It's not under land, which is up in 8. But indeed, it is assets that I own. And I think that miscellaneous was the place for me to put that.
And you didn't put it under land, because is it your understanding that land relates to land within the Virgin Islands?
No, land, the condo that we're talking about is in a building with other, it doesn't include a plot. It does not include a plot of land.
I follow.
So the most appropriate place for me to put that was under miscellaneous.
Now, taking the wider question, and that's the purpose, the paragraph 10 takes you back to the purpose of the form. And so
yeah.
What in your view, is paragraph 10 intended to do?
Capture anything that you have of value. So significant value that does not fall within the categories 1 through 9 in this particular paragraph.
Now, you said it's to capture anything that you have. So
significant value.
Do you limit the paragraph to assets that are held by the member, or do you think it captures other persons within that member's family?
By the member. Had it meant anything different, it would speak to the same. It would speak the same language as paragraph 9. Paragraph 9 speaks of other people besides the individual. This paragraph doesn't.
So it speaks of, as you point out, paragraph 9 speaks of the spouse and dependent children, doesn't it?
Right.
Now, if one is looking back at the preamble at 142, would you accept this, that in completing this form, what the member of the House of Assembly has to do is to keep in mind that they should be declaring interests which others might think could influence their conduct as a member of the House of Assembly?
Others. In the Virgin Islands, there are a lot of others for several reasons, and you can never satisfy all these others that you may be thinking about in this document. I think that the members, including myself, were quite clear on this bill when it was made, what the form is saying. And if they had any intent at the time to capture anyone else, they would have put it in here, because it's mentioned before. It's not that it's an oversight. It's in the forefront of their mind. Anyone other than the member is captured in this document already. If they wanted to put it in this particular paragraph, they would have put it in there as well. It's not that they didn't know about it.
It may be the way I phrased my question. What I was taking you back to, if you look at page 142 in the bundle.
Yes.
And that's the preamble. The preamble is where there is a reference to others. So
I see that.
It doesn't come from me, it comes from the document itself.
No, I understand that. But you're saying that others might perceive, and I said to you that it is pertaining to the member, and you asked a question whether or not it shouldn't be pertaining to members' families and others. And I said no. If it was, then the drafters of the bill and the legislators who passed it would have put it in that particular paragraph because they know it exists. But they chose to put it in paragraph 9 only.
Mr. Fraser, I understand that. I understand that interpretation. I think, and this isn't something we've investigated with, I don't think, any of the other witnesses, but there seems to me to be an internal ambiguity within the form in this sense. If you look at the preamble to which Mr. Rawat has referred, it says the main purpose of the register, so this is when we're looking at a purpose of instruction, this helps. The main purpose of the Register of Interests is to provide information of any pecuniary interest or other material benefit which a member receives. So that's restricted to a member on its face, not family. But in various places within the paragraphs, paragraph 9 will do, because we've been looking at that, shareholders. Do you have either yourself or with or on behalf of your spouse or dependent children interest in shareholdings? So there's a potential ambiguity there, because the purpose refers only to the pecuniary interest or other material benefit which a member receives, but that includes, in paragraph 9, shareholdings which a spouse or a dependent child receives. That seems to me to be an internal tension within the form.
Well, they deviate in that particular instance, but for the rest of the document, it held true to the preamble.
No, sorry, I understand your construction, but there seems to me to be that tension within the document.
I don't see the tension. I really don't. The preamble, as I see it, seems to suggest that there are no ulteriors in the document. Just answer the questions as they're posed truthfully. There are no tricks in it involved. The way I am getting it from the commission today is that in order for a member to fill this form out, even a member who was a part of making the bill needs to hire an attorney, because the interpretations that I'm hearing didn't factor when we were making the bill.
I understand that. I understand your construction, but other members have regarded paragraph 10 as including interests which are held by family members.
I've heard other members say that they didn't get advice and they need consultation and all the rest of it. I heard all that. So I'm not going to particularly sit here and say that you've heard from. Well, members claim that they're not au fait with the bill.
But your evidence is that in your view, each paragraph is, and all members have to do is to respond to that clear paragraph?
Truthfully.
Of course. Yes.
Commissioner, I am under no illusion that you might be of the view that this form needs to be amended. The bill needs to be. I'm not under an illusion that you might be under that view. However, and I can support the fact that you would like to see it, some form of reform, and you'd like to see it amended. However, what I can't accept is myself or any other member being judged based on what you think should be. I think we should be judged on what is.
No, that I think, with respect, misses the point I was making. The point I was making is not what I think. It's that individual members of the House of Assembly construe this form differently. You think it's clear. Others, I think it's clear, but have a different interpretation. Others think that it's unclear, and that's the only point.
One of the good things about this is that I'm here today, and in the coming days, you will be meeting with other members who were there when this bill was made. And one of the things that really intrigues me is when I listen to a court of law using bills that we have created, we made into law. They never refer to the objects and reasons. They just interpret it just the way they see it and from their legal minds. But sometimes it's far from what the lawmakers had in mind. But what can we do? Once it's passed, it's out of our hands. And we have to abide by your interpretation.
Mr. Fraser, that as a proposition is correct, but this is not a court of law. And secondly, Mr. Albert was referring you to the purpose of the form, that's all.
Okay.
Okay, thank you, Mr. Albert.
If I
I think Mr. Rao expected this today.
I'm sorry, what was that? What was
said, Commissioner said, I think he expected this today. He expected to have this between us.
Well, what I hope and what we are getting, Mr. Fraser, is that you're giving full answers to my questions, and it is very important to hear from you because, as we've established, you are a long-serving member of the House of Assembly. A while ago, the Commission explained to you that one of the issues that he is interested in is how the system works. Now, you have provided to the Commission your declaration forms, and then they cover 2013, 2020. So there is a substantial amount of paper. But what I'd like to do is just try and take all of that paper, which has been provided to you in a chronological way. But I'm not going to take you back necessarily to 2013. What I'd like to start with is page 238 in the bundle. And it's taking you back to 2015.
238?
Yes, please. If I've taken you to the right page, you should see a letter from the Registrar of Interest, Victorine Romney Varlack, dated the 26th of August, 2015.
Yes.
It's addressed to you as Third District Representative, and she says there, I quote, "I wrote to you on 17th of June 2015 regarding the filing of a declaration of interest on 23rd of June 2015, the date on which it became statutorily due. At this date of writing, 26th of August 2015, I've not had any response from you. I remind you of the requirement to file such declaration and request that you do this soonest." If you were going through the documents, if you turn over to 237,
yes.
on the 19th of January 2016, the registrar wrote again to you in these terms: "I write to remind you of your past due declarations of interest, which fell due on 8th December 2014 and 23rd June 2015. It's imperative that you seek to have this outstanding matter rectified. If you go to 236,
Yes.
on the 11th of May 2016, the registrar wrote again to you in these terms: "Dear Sir, I am to remind that your declaration of interest for the periods 8th December 2014, 23rd June 2015 are now overdue. I hasten to encourage you to seek to correct this situation. You will be aware that another filing date is fast approaching and another declaration will be due." And she then adds in brackets, Section 3 of the Register of Interest Act 2006 refers. Now, if you turn over to page 235, on the 24th of May 2016, the registrar wrote to you, and she wrote as follows, quote, "Dear Sir, June 23rd, 2016 will mark the first anniversary of your taking office as a member of the third House of Assembly following the general elections of 2015. As a member of the House of Assembly, you are required to file a declaration of interest on each anniversary of taking office as mandated by Section 3 of the Register of Interest. I take this opportunity to remind you and indeed encourage you to make your declarations of interest on the form provided herewith to reflect your interest as of 23rd June 2016. The letter continues, but I won't quote any more of it. If you go to 234 in the bundle, "23rd of August 2016, the registrar writes to you again. Dear Sir, please refer to the copies of correspondence dated 11th of May 2016 and 24th of May 2016 respectively, and seek to have these outstanding matters rectified without undue delay." And so what the registrar was reminding you there was of the need to file your 2014 declaration, your 2015 declaration, and your 2016 declaration. If you go to now page 231, please. On the 13th of December 2016, the registrar wrote to you in these terms. "Dear Sir, I make reference to my letters of 23rd August 2016, 11 May 2016, and 24 May 2016, regarding your declarations of interest for the periods 23rd June 2016, 8th December 2014, and 23rd June 2015. Kindly revert at your earliest convenience." And she continues, "Please either come into the office or call me sooner so that we can have this matter rectified." If you go to 230, this is a letter from the 1st of March 2017. It's headed Declarations of Interest, and the registrar writes as follows: "Please refer to my letter to you of 13th December 2016 and respond with your declarations of interest for the periods 8th December 2014, 23rd June 2016, 2015, and 23rd June 2016. She continues, quote, "As this matter is long overdue, I hasten to remind you that you continue to contravene Section 3 of the Register of Interest Act 2006. I am confident that you do not wish to maintain this position. I therefore expect to hear from you soonest," end quote. If you go to 229, on the 29th of March 2017, the Registrar of Interest wrote again to you, and it was in these terms: "Dear Sir, declarations of interest 8th December 2014, 23rd June 2015, and 23rd June 2016. My letter to you of 1st March 2017 has gone unheeded. Your declarations of interest for the period 8th December 2014, 23rd June 2015, and 23rd June 2016 remain outstanding."
I wasn't in correspondence with her. I might have seen her and spoke to her. Most likely not about this, but it's casually maybe.
Your voice is dropping a little, Mr.
I said
Fraser.
just probably, I might have seen her during that period, in a social setting maybe, but not professionally.
I see.
And definitely from 2014 to 2017, I would have seen her at Standing Finance and she would raise the issue about delinquency.
I see. Under the Act itself, and you've made the point that you were there when it became law.
Yes.
We've seen that one of the letters is actually a notice letter to members of the House of Assembly like yourself, notifying you of the date on which your declaration is due and what you need to do, and indeed giving you a form. Under the Act, it's right, isn't it, that there's no actual requirement on a registrar of interest to do that?
Just come on. My screen is blank.
Oh, sorry, just hang on a second, Mr. Fraser. Mr. Fraser's screen has gone blank, if that can be looked at, please.
Thank you.
Yes.
It's okay.
Thank you.
Good, thank you.
Are you ready to continue?
Ready to go, yes.
Thank you. I was putting this to you that under the Register of Interest Act, there's no requirement on any registrar, is there, to send a member of the House of Assembly a notice telling them of their obligations?
Oh, then our registrar was overly kind to us to send us notices repeatedly.
Nor is there an obligation on a registrar to send any member of the House of Assembly's letters reminding them if they are overdue and have missed the date. Would you agree with that?
I don't know if that's what the law says. I'm not sure.
Right, well, I won't press the point. Can I look at the
I've
declaration?
seen so many of those, I would figure that it was our obligation to do it.
Or it could have been, as you pointed out, an act of kindness on the part of Victorine Romney-Varlak. Because the obligation on her is to write a report if you are more than 3 months overdue of the date on which the declaration should be submitted, isn't it?
Although, as I understand your evidence, Mr. Fraser, there is a statutory obligation under Section 7, where a member is more than 3 months in breach. There's a statutory obligation on the registrar to send a report to the standing committee. But my understanding of your evidence is that until 2017, there was no standing committee.
Right. That
So,
is correct.
so it was not a very effective system.
Well, the question will be now, what good has the committee done? What good has having a committee done? I'm sure we'll probably get to that before we leave today.
If we look briefly at the declarations that you then submitted in April 2017, you first of all sent at that time, on that date, your declaration for 2014, and I'm going to take you to the copy that the Registrar of Interest has given to the Commissioner. If you go to page 221 in your bundle, this is the first page of your 2014 declaration. It is stamped by the registrar as received on 12th April 2017.
Yes.
But if you go to page 228,
Yes,
Can you confirm that that is your signature?
it is.
And you've dated it December 8th, 2014, and that's in TypeScript.
No. Oh, yes, in TypeScript.
Yes.
Yes, I did.
If you go to page 213 now.
Yes.
I'm taking you to your 2015 declaration as received by the registrar, and she's again stamped it April 12th, 2017.
Yes.
The last page of that document you will find at page 220.
Yes,
Again, can you confirm that that's your signature there?
it is.
And in TypeScript is the date June 23rd, 2015.
Yes.
If you go to 205, please.
Yes, I'm there.
This is now the last declaration that you submitted under cover of your letter of the 10th of April to the registrar. It's your 2016 declaration. She again stamped it as received on April 12th, 2017. If we go to page 212. Again, is that your signature?
That's my signature.
And it carries now the TypeScript date, June 23rd, 2016.
Yes.
Now, these three declarations have all been submitted substantially after the date they were due, haven't they?
Yes.
But you have dated each one with the date on which they were due.
That is correct.
Why didn't you date them on the date that they were completed?
You notice that each time she writes, she tells you which one is delinquent. And that's what I'm responding to, the delinquency. She said it's June, if she said it's June 23rd, 2016, I responded to that with that date. That's what it's for.
So again, taking you back to being there when the law was made, was it your expectation as one of the lawmakers that no matter how late you are with the declaration, you should date it with the date on which it was due?
That's my status at that date.
But doesn't that risk that doesn't that carry with it the risk that the wrong impression is given?
What do you mean by the wrong impression?
Well, if you date it with the date on that it's due, but in fact you submit it a year later, are you not giving the impression that you completed the document on the due date?
No, she would have, I don't know what her filing system is, what the registrar's filing system is all about. If there's a bin for 2016, there's a bin for 2015, and you just drop whatever belongs in there. But the date she received it, she has it on there. It tells, you don't need to be a rocket scientist to realize that it came in on that date because she stamped it.
And so it's down to the registrar to keep a record of when she receives documents and declaration. And
it tells what my status was at that particular time. If I was to submit a declaration late and my status changed, let's say I had holdings on the 2014, but I submitted it in 2015 and I have no holdings, and I was to record that I have 0 holdings and all that stuff. That would be false.
Why do you need to put if you're giving the information as of the date the declaration is due?
Yes.
Why can't you make that clear on the form by endorsing it rather than by giving the date on which it was due?
Endorsing it how?
Well, adding an entry in your miscellaneous section, or making clear at the bottom that you are giving a declaration as of 2017, you're giving your declaration of your assets as of 2014.
Maybe you could do that. That's your choice. But I choose to respond to the particular date that it was due. It's for that date.
Can I just ask you just to clarify a point, because independently of the registrar, you provided the commissioner with your own declarations of interest as held in your own records, and it's right, you have retained the declarations or copies of the declarations of interest that you submitted to the registrar.
Yeah, the funny thing about, you talk about the delinquency and all that. Delinquency has, for some people, has something to do with logistics. And for instance, all the documents I got to you came electronically. And it could have been done 5 o'clock in the morning, 6 o'clock in the afternoon, or whatever time it was, or Saturday or Sunday, it came electronically. But the declarations, I mean, it's a document that you walk up to the door with and drop it off. I'm not suggesting, I don't know how it could work if we were able to do it electronically, but I'm not suggesting that that be the case, because I'm not sure that the security measures can be attained. But in the case of you, the COI, it wasn't difficult. I had records of those. I was able to send them in.
When you, I think if I can try and break it down, first of all, is you kept records of your declarations of interest?
For the most part, yes. It had some cases we had to go through a period of hurricane and all that stuff that caused a lot of disruption. So you can't be so sure.
Were the records that you kept electronically or in hard copy?
Electronically.
Yes, thank you.
If you go to page 228, please.
228?
Yes, please. This is your, we're looking at your 2014 declaration as received from the registrar. It's the last page on which your signature appears, and you've confirmed it as your signature.
Yes.
If you could hold a finger at that page and then turn forward to page 30. This is the last page of your 2014 declaration as you provided it to the commissioner. So this came directly from you and your records. It carries the same date in typescript, December the 8th, 2014. And is that your signature?
Yes.
But if you compare pages 30 and 228, you said in both of them carry your signature, but what's there appears to be slightly different.
Yes, because the signature is not electronic.
That's why I asked whether you'd kept them in electronic form.
I figured you.
Yes. So in providing the documents to the commissioner, did you print off the electronic version and re-sign it?
Right.
I see. So that explains the difference between the two documents.
I mean, it does, Mr. Fraser, because you signed two different documents. You signed one document in 2016 and one document to send to us.
Right. Whereas a document that was sent to the commissioner, which is on page 30, might be an electronic signature. The one that went to the register of interest is not, because she got her hard copy.
I see. So you delivered a hard copy to the registrar, and when you provided it to the commissioner directly yourself.
That was electronic, so that's I think that's an electronic signature on this one.
I follow. Thank you. We're at the stage where you were to use the word of the registrar delinquent in relation to 2014, 2015, and 2016. The obligation on you as a member of the House of Assembly under Section 3 is to submit those declarations either on the day you assume office or on the subsequent anniversary of that day. Do you accept that in relation to those 3 declarations, you were in breach of Section 3?
Yes.
In relation to those 3 declarations of 2014, 2015, and 2016, they obviously reached the registrar more than 3 months after the date on which they were due.
Right.
That's Section 7. Do you accept that in relation to those 3 declarations, you were also in breach of Section 7 of the Act?
Right.
Could you go to page 203, please, in the bundle? This is a letter dated 14th of June 2017, addressed to you. It says, "Dear Sir, June 23rd, 2017 will mark the 3rd anniversary of your taking office as a member of the 3rd House of Assembly. According to Section 3 of the Register of Interests Act 2006, a member is required to file a declaration of interest on the date on which he assumes the function of his office and on each subsequent anniversary of that date. A declaration form is now provided for you to file your declaration of interest and that of your spouse and or child as at 23rd of June 2017. I look forward to receiving your declarations of interest on or about 23rd of June 2017. As 23rd June falls on a Friday, I would receive your declaration of interest on Tuesday, the 27th of June 2017. And so what the registrar is doing there is giving you as a member of the House of Assembly a notice again of your obligation arising under the Act. That's right, isn't it?
Yes.
If you go to 47 in the bundle.
47?
Yes, please, 47.
Yes.
This is the first page of your 2017 declaration. It's the copy that you supplied directly to the Commissioner. And if you go to the last page, which is at page 54.
Yes.
It's dated June the 8th, 2017.
Yes.
So just so that we can just be clear in terms of the chronology, that's obviously dated before you had received the notice letter from the registrar. So did you submit your 2017 declaration either before the date it was due or on the date it was due?
2017.
Yes.
Don't you have one from her with a stamp on it?
I'm sorry, your voice has dropped again.
Don't you have one from her with a stamp on it?
No.
That's strange. That is strange. 2017. You have 18 and 19?
Yes, I'll take you to those in a moment. But
And
it's
20?
Yeah, yes.
You don't have 17?
In a small, it's a small point, and you may not remember now, given it's a few years ago, but it goes to this, Mr. Fraser. Do you remember just providing your 2017 declaration on time?
I don't know, because she must have it. She must have had it because it's not in her notes, which I responded to.
Okay, well, it's perhaps something you could look into, but it's not something I think we need to take further now. If you go to 202 in the bundle.
Just 1 second. Just 1 second. $18, $17. I have a June 2017 from the registrar here in this bundle.
Okay, well, let's take me to it.
Page 176.
And it's stamped 23rd of February 2021.
Okay. And then you went back to and you have a June on page 47. You got a 2017. You go back to 170, page 176. You have a 2017 as well.
So
that's the one that was submitted to her.
it stamps it as received in 2021.
2021. 17, 18. What's the letter? She would have a letter from me as well.
Well,
can
can we pause that and I'll come back to it, because I'll take you through the correspondence and we
can remember the page?
Yeah, we can get to the letter that you sent to her as we go through the correspondence.
Okay.
But I will allow you to deal with that point.
Okay.
If you go to page 202.
A second. What do I got?
Yes, it's now the notice letter for 2018. So on the 23rd of May 2018, the Registrar of Interest writes to you and says, "Dear Sir, June 23rd, 2018 will mark the 4th anniversary of your taking office as a member of the 3rd House of Assembly. Section 3 of the Register of Interest Act 2006 mandates that a member of the House of Assembly is required to file a declaration of interest on the date on which he assumes the function of his office and on each subsequent anniversary of that date. A declaration form is herewith provided for your filing of your declaration of interest and that of your spouse and child as at 23rd of June 2018. So again, giving you notice of the need to file your declaration for 2018 by 23rd of June 2018.
Can I say something regarding this?
Yes, please.
I want to go back to 2017. I note keenly that the 3-month deadline was 1 day after, which was the 8th of September, 1 day after that humongous disaster that the territory suffered, called Hurricane Irma. If I missed that 3-month deadline, if I fell afoul of that 3-month deadline, I had 1 day that was eclipsed by Hurricane Irma. Nothing was the same after that for 2018, 19, or whenever, whose offices, including mine, that wasn't decimated, destroyed, documents destroyed. This same room that we're in was used for the House of Assembly meetings. High school has been destroyed and is still not rebuilt. The government administration complex destroyed, is now being worked on. Government offices have been distributed throughout the territory. I don't want anyone to get the impression that that disaster didn't have an impact on this territory. I am more concerned about people who doesn't have roofs over their heads. I stood in knee-high water, ankle-high water, distributed food in a community center in my district that has not been rebuilt yet, still working on. Ellis Thomas down the racetrack is destroyed. So I want to see some context in this whole thing. I know that you're concerned about the declarations of interest, which we were supposed to Commissioner, we were supposed to declare. In my case, my declaration has remained the same for the 16 or so years since this thing has been in, the act has been in place. I'm not looking for any excuses, to make any excuses, but I'm just telling you the facts.
Mr. Fraser, we certainly do not underestimate the consequences of the 2017 hurricanes, or indeed later the COVID pandemic. But we've been through in some detail the correspondence that you've received from the registrar in respect of your 2014, 15 and 16 declarations. They were all put in 2017. The 2017 declaration is a slight mystery because the date stamp that the registrar has put on it is 2021, but all of the correspondence, which is in the bundle, which she sent you between 2018 and 2021, none of it refers to the 2017 declaration. So it looks as though, although we haven't got a date stamp version, that may have been put in 2017. But
no, I think it was put in 2021. But if you go to my letter, my letter might clear it up. I'm not sure.
Okay, but 2017 is not clear. But just putting 2017 to one side, the correspondence which Rawat, I'm sure, was certainly going to go through for the next 3 years is very similar to the correspondence you've had earlier from the registrar, regular correspondence referring to the declarations that were due in June 2018, March 2019, March 2020. And those dates when the declarations were due are repeated in correspondence on a regular basis through to the 5th of January 2021, which is on page 184.
Commissioner, I'm not refuting that at all.
And there she reminds you that the declarations are due for 2018, 2019, 2020, and then they're put in January 2021. Now, I understand the point you make that the substance of your declarations hasn't changed. I understand that. But we're dealing here with governance and process. And in terms of process, you were delinquent for 3 years from 2014, and then for, I think, 4 years through to 2021, when declarations were simply not submitted on a regular basis, despite the fact that the registrar had sent you polite but persistent reminders. Is that the case?
That I was delinquent?
Yes.
Yes, I was.
And Mr. Rawat's already put it to you in respect of the first three, 14, 15 and 16, but in respect of 17, 18, 19 and 20, again, breaches of section 3 and section 7, because none was made within 3 months.
Correct.
Yes, thank you. I just thought that may
Shorten matters.
matter slightly, Mr. Rao.
Thank you. Unless you require me, Commissioner, I'm not going to take Mr. Fraser in light of his answers to all of that correspondence. But if I could take him to page 151 in the bundle. You've and this may clear up what your position was, Mr. Fraser, but it's a letter dated 23rd of February 2021, and you respond to the letter of March 10th 2020 from the registrar, which was the most recent letter she'd sent you. Well, it wasn't in fact the most recent letter, but it's the one that you chose to respond. I think that the most recent letter she sent you was on the 5th of January 2021, but on the 23rd of February.
Just a second. I'm responding to her letter of you said, well, where does it state that I'm responding to a particular letter? March 10th.
Yes.
You seen the March 10th letter?
No.
That's March the 10th, 2020, nearly a year before. But I'm not sure that we have that letter.
No, but the last letter before that response.
Every letter in here.
The last letter that you had from the registrar before that response is at page 184.
Page 184. Okay, page 184 does refer to March 19th, March 12th. No, 184 is January 5th letter.
Yes, so on January 5th, she'd written to you reminding you that there were outstanding declarations. And then
she doesn't mention 2017.
No, but if you go to your letter at 151, you say, I respond to your letter of March 10th, 2020, reminding me of my obligation to file my declarations of interest on my anniversary, March 12th, 2020. Pleased to report that the said declaration, together with those for 2016, 17 and 18, which my records show were not submitted, are attached for your use in accordance with the provisions of Section 3.
I think the reason I responded to mention March 10th is because they may have had all the years on that particular letter.
But you had already by this time submitted, in fact, your 2016 declaration that you'd done back in April 2017.
Okay.
But if you turn over, I mean, the first declaration that was sent under cover of that letter is stamped by the registrar, and she's put the manuscript date of 27th or 23rd of February 2021 there. So there are, and that includes a 2017 declaration. So it would seem that as of February the 23rd, 2021, that's when you submitted your declarations for 2017, 2018, 2019, and 2020.
I think that records with your recollection, Mr. Fraser, when you said that you thought 2017 was submitted in 2021.
Right.
Yes.
Mm-hmm. So I won't take you to the declarations themselves, because as you've already acknowledged to the Commissioner, you accept that you were delinquent and that you were in breach of the Act in serving these late.
According to the dates, of course. So what can I say?
And again, just for the record, but we don't need to look at it, but that you've dated them on the dates that they were due.
Right.
But obviously, as you've pointed out, the registrar stamped them with the date that they were received.
You have to understand that we don't know the system that the registrar used. We are not familiar with her systems. So you send it in for the date that is due. How she files it, I don't know. Her means of determining when she got it is important, so she put a stamp on it.
But independent of her approach, there is still a statutory obligation on you as a member of the House of Assembly to file it on the date that it's due, isn't there?
It is.
Can I just ask you what the position was in relation to your 2021 declaration? That would have been due, I think, in 12th of March 2021. Did you submit that on time? Or did you have it ready to submit on time?
Did you get it from me? I sent it yesterday.
Well, if you go to 141, 142 in the bundle.
(142)?
Yes. That's the first page of it as received by the registrar, and it's stamped and it's dated the 26th of May 2021.
It was due when?
Well, it would have been on the 12th of March 2021. But if you look at page 139, before you answer, Mr. Fraser, look at page 139. And you'll see why I've asked the question that I have. I'm not going to read the letter out in full, but on the 5th of May 2021, the registrar had written to all members explaining why, referring to a letter she'd written in February asking members to submit their declarations of interest by 12th of March 2021, explained why she was then unavailable for a period. And that had been explained by the Office of the Clerk of the House of Assembly to members. So there may be reasons to explain why the registrar's stamp on that day carries a stamp of May 2021. But my question is, do you remember having it ready to submit by the 12th of March?
My letter is dated March 12th. Yes, it was ready to go then. But I got correspondence from the registrar indicating that she was going to be ill. I mean, she was going to be out due to illness. And as a result, we should hold off on submitting because there's nobody to submit it to. If I'm still waiting, if I was waiting to get a response as to when I should bring it, I certainly got this one, the same one that you have, it's dated May 5th.
So to summarize it, at least in 2021, your declaration was ready to be filed on time.
Exactly.
Can I move on to just another matter briefly, and that is an issue that we have asked other members of the House of Assembly to help with, and that's how the system for allocating assistant grants works. And I just wanted you, if you could just confirm the position.
Before we move on to that, if I may, I'd like to say that I need to enter into the record that the perception on the street might be that members of the House of Assembly are a group of rogues who, under this particular act and their responsibility to declare their interest, is left alone to themselves and they do anything they wish. But that is far from the truth. If you look at the act itself, under section 5, subsection 4, it says, where the registrar is satisfied that an entry into the register has been made as a result of a fraudulent or materially misleading declaration by a member, A, the registrar shall, 1, mark the entry as canceled, and 2, by notice required a member to make a new declaration in respect of the interest held at the date the fraudulent or materially misleading declaration was made. And B, the member shall be required to make the new declaration within 28 days from the date of the notice. Subsection 5 says, the registrar shall mark as cancelled any entry which has been incorrectly made. So it's not as if members can submit anything they wish and get away with it. It's not as if members can do anything they want with a declaration. And as you pointed out aptly, the Act does in fact have a deadline by which these things are supposed to be submitted. And the 30 days is beyond the 30 days, you're in breach. So I think that I've heard you speak in glowing terms about the responsibilities of a committee, and it's your hope that a committee can remedy what you've seen taking place. I'm not sure. And I think that when it comes to governance, I'll be able to elaborate more as to why I'm not sure, Commissioner, about your hopes and aspirations for remedying what you see happening here now.
Mr. Fraser, we're looking at the system, and although there are provisions in the Act, one of which you've referred to, whereby the registrar has powers to, in respect of sanctions, where a declaration is wrong, the picture that the evidence paints is firstly that members of the House of Assembly put in declarations late or, with respect to you, very late in some cases. Secondly, under Section 7, and this is not a criticism of the registrar, but it's a fact, under Section 7 of the Act, under which the registrar has to report a member who is over 3 months late to the standing committee. That is not done. You've referred to one instance. We have no documents in relation to that, but generally it's not been done. Thirdly, the standing committee which oversees this, on your evidence, didn't exist until 2017, and on the evidence that we've had to date has never met, with the sole exception to which you've referred. And the standing committee, of course, is of members of the House of Assembly, some of whom are in breach of their obligations under the Act. Now, as a system, at the moment, that doesn't seem to me to be an effective governance system. You say that there may be things that we can do to that can be done to improve it. There is a bill that's been drafted which may address some of these issues, but simply in terms of the governance system, the system in the 2006 Act does not, on the face of it, seem to be optimal.
From what I know, Commissioner, I'm not sure that the committee is privy to declarations. I don't think the registrar can, in fact, divulge of the declaration of a member to the committee.
Another issue is the extent to which the registrar can show what has been declared to anybody, including the standing committee, including, we've heard from some witnesses, to the members of the House of Assembly who their own declarations. So it's very restrictive in terms of publicity too. But these are matters that, as I say, I'm looking at the system at the moment, and the evidence that we're receiving on the system is very helpful to build up a picture in relation to it. Yeah. Yes, Mr. Rowland.
To move on, and I hope try and take it briefly, I'm going to try and summarise the evidence from other members of the House Assembly to see if you agree with it, Mr. Fraser. The first is that all district representatives have access to a fund which is $125,000 a year, and which is allocated on a quarterly basis.
I want you to explain what you mean by access.
Well, that they can distribute assistance grants.
We can trigger the mechanisms to assist individuals from a vote that's held by the clerk of the house. We don't have access to the money.
No, but you will receive an application. This is the evidence that others have given. Someone will submit an application to an elected representative.
True.
The elected representative will make an assessment of that application.
True.
They will determine whether it should result in an assistant grant or not. The application then goes to the clerk to the House of Assembly, who also undertakes a review. If the clerk has a concern, it will be returned back to the member. If there is no concern, it then goes to the Treasury Department, who, to borrow Minister Wheatley's phrase, cuts the check. And then that is then distributed. The check goes back to the House of Assembly, and it's distributed from there. It doesn't go straight away back to the member. The Treasury Department can also raise a concern.
You said that the check doesn't get to the member?
Well, it doesn't. Minister Wheatley's evidence yesterday was that the check doesn't sort of go straight from the Treasury Department to the member. It goes via the House of Assembly.
Yeah, but it does end up with a member.
Yes.
Yes.
And it's distributed then.
Yes.
And that would you accept this proposition, which is the evidence of a number of members of the House of Assembly, that the amount that they can allocate each year is never enough when set against the number of requests for assistance that they may receive during the course of the year?
Let me say that the requests are greater than the amount that we have.
And so there is an exercise to be done of a difficult exercise of trying to assess the merits of each application and who you can help and who you can't.
It's difficult. The reason I didn't answer your question straight is because enough. What is enough? It's never enough, because last year we had $225,000 as opposed to a regular year where you have 125,000. I wouldn't even mention the 300,000 on top of $25,000 last year, and it was never enough. It was not enough. So the more you get, it's as if this sitting is going to do wonders for that vote that we have now. When I say wonders, I mean you're going to request to go in a bush room after they see this.
If I just one point on the there are guidelines the Commissioner understands which are issued. One set of guidelines that are issued to all members of the House of Assembly for processing assistant grants that allows for district office expenses relating to rent, staff and operating expenses up to a maximum of 24,000 per annum. So a district representative might not choose to do this, but that they can use some of that money to fund an office in their district. Is that right?
That's right. How old is those guidelines that you're looking at? How old are those guidelines that you're looking at?
That is a question I can't answer, but they are, as we understand it, the guidelines that members of assemblies
I can assure you that they're more than 15 years old.
We've asked the question, Mr. Fraser. We're waiting for the answer. I mean, this is not a complaint. We only asked the question yesterday, but we've asked the question.
So $24,000 back then and $24,000 now, you can see the difference.
And so your evidence is that they haven't been updated in 15 years.
They haven't been. They haven't been. And I'm surprised that members has access to that list of guidelines.
Why are you surprised that they have access to those guidelines?
I haven't seen one of those for a while. from the time it came out. And the last time we were asking about it, I don't know where it came from. I haven't seen it. You have a copy of it, but I'm familiar with it. It came at the time when Attorney, your colleague Benston, Mr. Fraser, was clerk of the House of Assembly. You could ask him what years they were.
Well, the copy of the guidelines, in fact, that we are referring to is a copy that was provided by Mr. Flinglestone Davis. Anyway,
That's where it came from.
that's where it came from. If I move on to a separate question, and that is the Constitution providing under Section 67 that the House of Assembly can vote to exempt a member from the need to vacate his or her seat if they are, to paraphrase, a party to, in some way, to a contract with government. I take it that you have never either sought exemption or been exempted under Section 67.
Correct.
Obviously, the motions may have come before the House of Assembly for seeking an exemption, on which you then have to vote as a member of the House of Assembly.
Yes.
I think we've had recent evidence from the Honourable Neville Smith, who explained the circumstances in which he sought such a motion from the members of the House of Assembly.
Yes.
In those circumstances, can you help the Commissioner with this? What information would be provided to you as a member of the House of Assembly before voting on the motion in order for you to decide which way you will vote?
We just get the request. It's simply the motion itself on a sheet of paper.
And is that then debated on the floor of the House?
Yes, there is debate. However, I think that members are not keen to debate each other on matters pertaining to each other. I would tell you what my position is. The fact that the Constitution provides for such an exemption means that the member is entitled to it. That's my position. I'm not going to stand there and try to argue against it.
What the Constitution asks the House of Assembly to do is it says, if in the circumstances it appears just to the House of Assembly to do so, the House may exempt any elected member. So my question is, how do you assess whether something is just or not?
That's exactly my point. The fact that the Constitution provides for it, that language is moot. Just. What is just? You don't know what just is yourself.
I don't need to. I'm not a member of the House of Assembly, which is why I'm asking you.
Even the guy on the street wouldn't know what it means when he look at it. What do you mean by just? If it's just? Of course it's just. The Premier took it to the cabinet with his members. He brought it to the House of Assembly. I am yet to see someone being turned down. I think there was a time when there was an argument on the floor regarding one such exemption. And I bet that member who stood up or tried to voice an objection to it never done it again.
And why did they never do it again?
They weren't as popular as they were before.
Mr. Commissioner, may I have a moment?
Yes, thank you.
Mr. Commissioner, those are all my questions. Can I conclude by thanking the Honourable Fraser for coming this morning, for giving his evidence, and indeed for the way in which he has given that evidence to you.
Thank you, Commissioner.
No, can I just echo that, Mr. Fraser? Thank you very much for your time. Thank you very much for your answers and the clear way in which you've presented your evidence. And I can't remember the time, but I think you're due to give evidence next week in relation to governance.
Next Tuesday, I think it is at 2 or something. I want sometime.
Yes,
it is next Tuesday.
I think when
it's Tuesday afternoon, I think.
We mentioned that to Honourable Fraser when he was here on Monday, and he confirmed that date is in his diary. And so we shall see him again fairly soon.
Good. Thank you very much, Mr. Fraser.
Could I ask you to rise briefly for 5 minutes so we can reset the room?
Yes, thank you very much.
Before I call on our next witness, just for the record, confirm that Mr. Denniston Fraser is here to represent the interests of our next witness, who is the Honourable Melvin Turnbull.
Yes, thank you.
Good. I think it's good afternoon now.
Yes, good afternoon.
Honourable Turnbull, you of course came on Monday when you were sworn, so there's no need for you to be sworn again. But first of all, can I thank you for returning to give evidence? I think we probably kept you a little longer than we promised to, but hopefully we'll get through everything in relatively quick order. There's no need either for me to ask you to give your full name or your address, because you did that on the last occasion. As I explained to all witnesses, I do try and keep my questions short and simple. Yes. But if at any time I put a question to you that you have difficulty understanding, please don't hesitate to ask me to repeat it or to rephrase it.
Certainly, thank you.
There are a number of bundles there on the desk. You won't need to look at all of them, but those that you do need to look at, I will take you in due course.
Thank you.
Final request from me, please remember just to keep your voice up, to speak slowly. And that's because that allows us to have an accurate and clear record of your evidence as we go through the hearing. Could I start, as I have done with all the witnesses who have given evidence in this session, and that is to ask you just to give an outline of your professional background before you entered politics.
Thank you, Commissioner. Thank you, Mr. Wright. Before I entered politics, my profession started in 2002, where I became an insurance agent with AIG in Hollywood, Florida. Then moving on to becoming an associate manager, subsequently moving back to the BVI in 2005, where I was the manager for a financial services firm, MWM Financial Services, responsible for pensions, investments, and retirement plans, as well as insurance. So my background prior to politics, in terms of educational background and professional background, stemmed on the field of finance. And then in 2013, I left my job and started a nonprofit organization where I was mentoring youth between the age of 12 and 18 to keep them out of the judicial system, to keep them from getting records. So I worked alongside with the Youth Court of the Virgin Islands, the Ministry of Education, Ministry of Health and Social Development, and a number of social organizations, including the health and community organizations.
Thank you very much for that outline. Can I now turn to your career as an elected representative? Is it right that you were first elected to the House of Assembly in 2015?
That is correct.
And that was as the member for the 2nd District, and you were elected as a member of the National Democratic Party?
Yes, I was.
And have you represented the 2nd District since that time?
That is correct.
Between 2015 and 2019, and please correct me if I've got this wrong, but the NDP was then in government.
Yes, they were.
Did you hold any ministerial office in that administration?
No, I did not. I was a backbencher, acted, I think, on 2 occasions, maybe 3, as one time, I believe, as the Minister for Health, and another time might have been Minister for Natural Resources.
Now, obviously, you were successful at the 2019 election, but you now sit as part of the opposition.
Yes, just by way of correction for the record, the record must reflect that before the end of the term, I left the government side and walked over to and sat as a member of opposition prior to the elections of 2019.
I see. So when you say you were sitting as a member of the opposition, was it for any particular party or?
At that time, I left and I was an individual independent candidate or representative on the opposition.
But for the 2019 election, you returned to the NDP fold, so to speak.
No, I didn't.
Oh, you're still.
2019, we formed a Progressive Virgin Islands movement, a new party that contested the elections.
I see. So you are now a representative of the Progressive Virgin Islands movement.
That is correct.
Thank you for that clarification. I'm sorry if I got it wrong.
Not
but
a problem.
to return to the second district, how many people live in your district?
There are about, I would say between 35 and 3,500 persons living in the second district. It encompasses part of Tortola as well as the island of.
Hopefully it will now stand up. Thank you, Mr. Rowett.
Thank you. Welcome back, Mr. Turnbull. One of the issues that we are exploring with witnesses in this session is the register and the system for members of the House of Assembly to be able to declare their interests as required. If you don't need me to do this, do tell me, but can I just take you to what the Register of Interest Act obliges you as a member of the House of Assembly to do, so that you can see the context of my questions.
Yeah, I'm aware of what it requires.
So you're aware that Section 3 requires you to, on the day that you're sworn as a member of this House of Assembly, to make a declaration, and then on each subsequent anniversary of that date.
Yes, sir, I am aware.
And are you also aware that if within 3 months of that date you haven't filed a declaration, then the registrar is obliged to write a report about you to a standing committee?
Yes, I am aware of it.
Now, the evidence of the Honourable Julian Fraser this morning was that that standing committee was only set up in 2017. Is that your recollection of when the standing committee in relation to the Register of Interest was set up?
If my recollection serves right, I believe after being elected in 2015, I believe that committee was in place shortly thereafter.
Were you ever a member of the committee?
No, I wasn't.
And did you, in that period, 2015 to 2019, did you learn anything about its workings or what it was up to at all?
In terms of the committee?
Yes.
No, I was made aware that neither in the third House of Assembly nor in this present House, the committee has never met.
And in this present House of Assembly, are you a member of the committee?
No, I am not.
Now, you as you've indicated, you are aware of your obligations. Do you keep copies of the declarations that you submit to the registrar?
The ones that I have submitted, I didn't keep copies, but I recently acquired the copies of all submissions made.
And was that by going to the registrar and asking for copies?
That is correct.
They are in the bundle for you. I just want to sort of quickly take you through them. If you go to page 134,
yes, I'm there.
hopefully, if we're on the same page, you'll see the first page of a registration form stamped July the 7th, 2015. Do you have that?
That's correct.
Now that, if you go to page 142, I'm taking you to the last page of that document.
Yes.
142.
Uh-huh.
Can you confirm, please, Mr. Turnbull, is that your signature?
Yes, it is.
And it's dated July the 7th, 2015, isn't it?
That is correct.
Now, in that House of Assembly, which was, as you said, the third House of Assembly, you were sworn on the 23rd of June, 2015.
That is correct.
So would you accept that in relation to this declaration, you were late in making the declaration?
Well, from the 23rd to the 7th of July, that's correct.
If we go to page 123 now.
Yes.
This is a declaration and it's stamped with the date June 13th, 2017.
Yes.
But if you turn to page 133, and taking you to the last page,
Yes.
dated the 13th of June, 2017. Sorry, I should have confirmed this. Again, confirm for us that it does carry your signature.
It does.
And in terms of the manuscript writing underneath, is that in your hand?
Yes, it is.
And what you've written there is 13th of June, 2017, but you've added for June 23rd, 2016.
That is correct.
So again, would you accept that again, you were late in submitting that 2016 declaration?
Yes, I would. I would confirm that. And Commissioner, if I may make a submission before this body. I am by no means, I take responsibility for the submissions that have been made late on my behalf. There are years where I've erred in not submitting my interest in a timely manner, and there's also times where my submissions may have been in breach of the laws of the Virgin Islands. Also, I have copies, and I admit that I have copies of reminders from the Registrar of Interest asking me to comply with the regulations of this act. And I by no means make any excuses. I take full responsibility for my actions, because I know as a servant leader of this territory, the buck stops with me as the leader, as the representative. And I want to also take this time to apologize personally to you, Commissioner, to the Registrar, to the people of the 2nd District and the people of the Virgin Islands for my tardiness, but this in no way, shape, or form reflects my overall representative and the serious nature in which I take the job that is afforded me and the people of the territory has bestowed upon me. So I just want to make that submission, please.
Mr. Rowett may take you to some of this, but some of the correspondence, but the correspondence we've seen from, in respect of other members, in particular, the last witness, Mr. Fraser, Honourable Julian Fraser, shows that the registrar was diligent in this sense, that she sends letters shortly before the due date for the declaration, and reminders on a fairly persistent basis following. And is that a picture that you would confirm that she sent these letters to?
Yes, she did.
No.
Yes, she did.
Yes,
that's correct.
If I could explain, Commissioner, and indeed to Mr. Turnbull, what I propose to do is to take my questions in 2 stages, effectively. Given that your answers, what I'd like to do, and it's in fairness to you as well, is take you to the individual declarations and just get on the record whether in each of them you accept that you were in breach or not.
Yes, sir.
But the second aspect of my questions would be directed to the details that you've put on some of the forms, but it's to seek your assistance as to how easy or not you found it to answer the questions on the form.
Okay.
So if we can do the first stage, if I may, I've taken you to page 123.
Yes.
If you go to the last page of page 123, which I think you'll find it as page 133.
Yes.
So that's where we were. So you submitted your June 23rd, 2016 declaration almost a year late, didn't you?
That is correct.
And so again, this is where you've accepted that you were in breach of the Act in regard of that declaration.
Yes, sir.
If you go to page 112,
yes, sir.
it's stamped June 27th, 2017.
Correct.
And if you go to, I think that the last page in this, you'll find at 122.
Yes.
27th of June 2017. So this is your 2017 declaration.
Yes, sir.
Now the date that it was due by was the 23rd of June. So in fairness to you, you were only 4 days out.
Yes, sir.
So I suppose technically you'd fail to comply with the law, but only by 4 days.
Yes, sir.
Now, if you go to 101, this is your 2018 declaration, and you'll see stamped on it is the registrar of interest's stamp, and although it's faint, she appears to have written in manuscript on it the date 2nd of June 2020.
I don't see it, but I would take, I can't make out the date on based on this copy. Yes,
Thank you.
based on this copy.
Now, if we go to the last page of that document, we will find at page 111.
Yes, sir.
And this is where I might need help with deciphering your handwriting, but again, that carries your signature, doesn't it?
Yes, it does.
Now, written next to it are the words in manuscript for 23rd of June 2018. Now, is that your handwriting?
The date is my handwriting. The date, the signature and the date are my handwriting. The note is not.
Right.
The note, I believe, is I would believe it comes from the registrar.
Right. Now, in terms of the date that you've written, my copy is rather faint. So can you just, for the record, just confirm what date you wrote under your signature?
June 23rd, 2018.
Now, she stamped that 2020.
Yes.
You've put it as June 23rd, 2018, which would be the, I think the date that you would have had to comply by.
Yes.
So doing the best that you can, in terms of 2018, were you on time or were you in fact late?
I was in fact late.
Thank you. If you go to 90 now.
Page 90.
We're now looking at your 2019 declaration.
Yes.
The stamp for the registrar of interest has, I hope you can read that, but the manuscript date there looks to be 4th of May 2019.
Yes, that is correct.
The last page of the document you will find at page 100.
I'm sorry.
I think it's the 4th of June, actually.
4th of June.
4th of June.
4th of June, sorry.
2019. Yes. Sorry, that was my fault.
Yes.
I apologize for adding confusion.
Not a problem.
If you go to page 100.
Yes, sir.
Now, that's the last page. Again, that's your signature, isn't it?
That is my signature, and the date is my handwriting.
And you've given the date of June the 4th, 2019.
That is correct.
Now, this is now the 4th House of Assembly.
Yes.
And you got sworn in the 4th House on the 12th of March 2019.
Correct.
So again, in relation to this declaration, you accept that you were late in submitting it.
Yes, sir.
If we go just to look at your 2020 declaration, which is at page 79.
Yes.
Stamped by the registrar. Again, the date may be clearer on your copy, but as I read the date that she's written in manuscript, it's 2nd of June 2020.
I can't make out the date on my copies. Yes, it is.
Thank you for confirming that. The last page of that document is at page 89.
Yes.
Again, is that your signature?
It is.
You've written the date March 12th, 2020 underneath that.
Correct.
Which is the date that it's due. But again, do you accept that you in fact filed it late?
Yes, I do.
Now, was there a reason that you wrote the due date down rather than the date on which you'd completed and filed the form?
When I had the conversation with the registrar, I asked what date I should put on there, and that's what she would advise me.
I see. So her advice was write the date on which the declaration is due.
Yes, sir.
Thank you. If I just take you now to your 2021 declaration, which I think we'll find a page. Well, it's actually it's actually to ask
68.
for your help with this one. If you go to 68,
Yes.
It's well, it would lead us to conclude that that's the 2021 declaration.
Yes.
But if you go to 78,
The date is 2020.
so you've put your signature, but when you write May 17th, 2020, did you mean May 17th,
May 17th,
2021?
2021. And I have erred in that.
So again, that one is late.
Yes, sir.
Now, just to now, slightly, I'm afraid we might be jumping around between different forms, but I just want now to move on to the topic of how you approach filling in the form.
Okay.
Now, if you go to, let's go to page 135, please.
Yes.
The first question that you're asked is directorships, and you're asked to declare any remunerated or unremunerated directorships in any company. We're looking at your 2015 form,
Yes.
and you've directed or you've declared there a directorship in a boutique,
Yes.
and that was that the position in 2015?
That was in 2015 because the license for that company was still in force up until 2015.
Now, some members have explained to me the difference between a company and a DBA.
Yes.
Was this a DBA?
This was a DBA.
Now, for some members, they would put their DBAs elsewhere on the form.
Yes.
Was there a reason you chose to put it under directorships?
At that time, I am not completely sure why I put it on the directorship at that time.
Thinking about the forms, and you've obviously filled a number
Yes.
of them. Do you think there's a lack of clarity in terms of the guidance that's given to honourable members as to how to fill in the form?
I would say so.
And I'll take you to some of the categories that you have to complete. But in relation to directorships in a company, can you assist the Commissioner with whether you think there's any ambiguity or uncertainty for you as a member of the House of Assembly?
Well, I believe, given this is just about 2 weeks after being sworn in, being excited to get busy for the work of the people. In completing this form, I believe I may have just filled in the form without proper clarity, but my wife and I owned this particular boutique.
I see. And do you still own the boutique?
No, the boutique is no longer a business.
Right. Well, if we go to 124 in the bundle, we're going to your 2016 declaration.
Yes.
And you directorships is empty.
Yes.
So by 2016 had the boutique ceased trading.
I believe probably within 2 months it was probably around September of 2015 that the business had ceased.
Right. Now, if you go to keeping it in page in 2016 at page 132. Under shareholders,
Yes.
you make a reference to Jean's Bar and Grill.
Yes.
And so you were declaring there that you own some shares in Jean's Bar and Grill.
Yes.
Now, when you look at 122, which is now 2017.
Yes.
That's the last category. headed miscellaneous, and you then refer there to Jean's, you say partner, Jean's Bar and Grill. So was there a reason you moved it from shareholders to miscellaneous?
Yes, there was. In 2017, the business opened in around April of 2017. And then the idea was to have an incorporated business, which then changed directly after we had to move locations from, we were in Carrot Bay and then we moved to Manual Reef. And shortly thereafter, we ended up with the hurricanes. And then we changed the entire structure to just being a simple company set up from the incorporated structure to just ownership.
See, well, if you go to 69.
Yes. And if I may add, Commissioner, at that particular time as well, the understanding was putting it under miscellaneous because the understanding was made to me that it had to do with doing any business with government. So I put it under the miscellaneous section because I wasn't, or none of my businesses that I have are doing businesses with government.
So what had been explained to you was that the purpose of the form was to declare anything that could be described as an association with government.
Yes.
And because Jean's Bar and Grill didn't have that association, you put it under miscellaneous.
Yes.
If you go to it's now 2021. I think if you go to page 69.
Yes.
You now put Jean's Bar and Grill under directorships. Was there a reason for that change?
The reason for that change because I am now partner of the business.
I see.
Yes.
Is it a DBA though?
Yes, it is.
Thank you.
But again, if it's a DBA, why do you decide to put it under directorships?
Because the partner that I am associated with prior to 2019 did not have the, I want to make sure I coin it the right way. In order to have a trade license in the territory, you need to have someone who is a national of the territory, belong of the territory, and the partner at that time was not prior to 2019. So I acted as sole director of the company, even though they were my partners. Now that they are belongers, it is in fact a joint partnership.
So in terms of actually this venture, as you've gone through your form,
it has changed over.
You've put it in different parts of the form because the nature or the framework of the business has changed.
Yes, sir.
Its structure has changed.
Yes, sir.
Right now, if we go to paragraph 2, and we can look at this. If I take you to 103. This is your 2018 form.
Yes.
Paragraph 2 asks you to declare whether you have any employment, office, trade, profession, or vocation, other than being a member of the House of Assembly or a minister, for which you are remunerated or in which you have any pecuniary interest. Now, you've put there Body UFit Health Club Limited.
Yes.
Now that's the first time that you, in your forms, declare remuneration.
Yes.
So that's when you started having remuneration from that company.
And Commissioner, if I may, this company is solely owned by my wife. So this section that deals with for which you are remunerated or which you are in particular interest, because it's my wife, I held on to those two last words because it is my wife's business. And I think because she is my wife, I declared it here.
I see. Now, we can take this shortly because you have, again, at different points, and this is in your 2020 declaration and your 2021 declaration also refer.
And sorry, Commissioner, I believe there is in fact an error in this particular submission as well. Now that I have time to review it, because the business in Fish Bay actually started in 2020, right before the lockdown. So I believe because this submission, if I am not mistaken, was done in 2020, I believe it was put there in error.
I see.
For 2018.
I see. So if you had been trying to accurately record what your the state of your interests were in 2018,
yeah,
you would have not put that in.
Correct. Because the business did not come into force until 2020. March 2020.
I think on page 103, by Body You Fit Health Club Limited, somebody has written 2018 question mark. That's
yes.
Not your writing.
That's not mine.
But maybe the registrar.
Yes.
I suspect, but so that may explain that. Yes.
Just to support your conclusion, Mr. Turnbull, if you go to 92, which is your I think your 2019 declaration under remuneration, you've only there made reference to Jean's Bar and Grill, haven't you? But when we look at your, and we can go to it if you want, but you may not need to, but when we look at your 2020 declaration, you do then refer to Body You Fit, which would fit in with your timeline for the creation of that company.
Yes.
Now, we can do this by looking, if we look at page 93.
Yes, sir.
Page 93, it refers to the third paragraph on the form, which is headed clients. And you've always answered no to that.
Yes.
Now, looking at that, what do you think the purpose of that paragraph is? What is it you're expected to declare there?
But if I may, for the record, just read it. Does any of the paid employment registered to categories 1 and 2 entail the provision of clients or services which depend essentially upon or arise out of your position as a member of the House Assembly? See note 1 above. Yes or no? So I believe I interpret it to be, if I am benefiting from my position as a member of a House Assembly based on the businesses, and the answer to that is consistently no.
So if, for example, and it is a hypothetical, you were to introduce Body You Fit Limited, your wife's company,
yes,
to a minister in order to promote its use in a health initiative,
yes,
you would have to write that you had done that in
I would not only have to write that I have done that, I will also have to make notice in the House of Assembly to declare my interest.
Paragraph 4, if you turn over the page, there are two aspects to paragraph 4, which is headed sponsorship, and I'll take the second one first. It's at B, and it asks whether you benefit from any form of sponsorship or financial or material support as a member of the House of Assembly, and you've always answered that no.
That is correct.
So that is, would you accept that what you're supposed to do there is to set out if you receive any kind of assistance or benefit to do your work as a member of the House of Assembly?
That's what I understand it to be.
So if someone offered you free accommodation, you would have to declare that.
Certainly.
Now, the first question is, did you benefit from any sponsorship before election where, to your knowledge, the financial support in any case exceeded in aggregate 2,500? I'm just going to draw your attention, but I won't read it out. Just to point 2 at the bottom in italics, which refers to Election Campaigns Committee. And I'm just going to ask you, please, Mr. Turnbull, if you could just explain to the Commissioner, what do you understand is meant by sponsorship before election?
Well, Commissioner, I believe in doing some research and having conversations with members of the House who were at the time present when this bill was drafted and passed, I believe it is actually void of another piece of legislation which should have come into force dealing with campaign financing. But solely specifically to the question that you have asked, sponsorships, I believe, if you've received any sponsorship for your campaign, and I believe I've heard you ask the question, maybe you haven't asked it yet, the difference between sponsorship and donations, which I believe there is, in fact, a succinct difference between sponsorships and donations. So to put it to you, I have not received any sponsorships prior to or knowledge of it before election.
And again, to be fair to you, Mr. Turnbull, you've always answered this question no.
Yes.
But you've raised the issue of campaign financing,
Yes.
and you've said that there is a difference between sponsorship and donation. Could you just expand on that? What do you see as the difference between the two?
Well, I believe when somebody sponsors you, they have part ownership or entitlement to represent their needs. For example, I'll use a very simple example. If I sponsor a basketball team, I would expect my logo or some sort of acknowledgement to be recognition to be displayed, whether it's on the teams, on the jerseys, whatever the case may be. If someone gives a donation, it's simply a contribution that has, I would put it in quotations, no strings attached.
But in the real world, someone might suggest that sometimes donations do come with strings attached.
I do understand that interpretation, but it is not the same as mine.
But in this case, then, on your interpretation of this form, you would not be required to record donations over 2,500.
On this form, specifically for
4A.
4A, no, because it's asking for sponsorships.
I see. So if I came along and said, you know, I'd like to sponsor you with a car which has my name on the side of it, that would be sponsorship. But if I were to donate you a car, that would be a donation.
Well, I understand
it's a hypothetical.
It's a hypothetical, but the reality for me, and that's why I've consistently answered no. The reality for me is whatever I do, I try to do it within the boundaries of the law. So anything that would question my integrity in that sense, my answer usually simply, and one of my favorite words is no.
But it's going back to the line you draw between donation and
Yes.
sponsorship, because your point is, as you read the form, you don't have to declare donations.
Well, based on the question that's asked in A, it asks specifically, about sponsorships. But I was only referring to questions that I've heard posed in the difference between sponsorships and donations.
Okay. Now, you alluded a moment ago to, you said a law that was void in relation to campaign financing. To your knowledge, and this is a question that the Commissioner raised with the Attorney General, are there any rules at present that regulate campaign financing in the BVI?
I believe there have been discussions, and over the six years that I've been sitting in the House, I know I can recall in the reports from the Supervisor of Elections Office, there have been recommendations made for the proposal of campaign financial legislation.
Have any of those recommendations been brought into force?
Not since I have sat in the House of Assembly. Not since 2015. Sorry.
This allows me to jump forward a little bit to a question I have put to other members of the House of Assembly, and I'm going to do it to you as well. And that is that if there was such regulation, that if you brought in legislation and policies that governed candidate and party financing,
yes,
or that required that for financial reporting purposes a political party be registered, would you agree that taking that step would increase trust in the system and also reduce the risk of corruption?
I will wholeheartedly agree with you, because at the end of the day, I believe it's important to have accountability and exercise prudence in terms of being a representative of the people.
Now, if you go just to 132, think we may have covered this, but it's the shareholders' point. In all your forms, with the exception of this form, which was your 2016 form, when you're asked about whether you own any shares, and there's obviously thresholds.
Yes.
It's shares above a certain value or a certain percentage. You said, no, I don't own any shares, but on 132, you referred to Jean's Bar and Grill again. Was this part of the fact that the structure changed? The structure of Jean's Bar and Grill as a entity changed over time, and so
if I am looking at the form, Commissioner, this is 132.9.
132, and it's page 132, paragraph 9.
Yes, I am seeing where no is crossed out and yes is ticked, has a check mark.
Yeah, and underneath you refer to Jean Bar and Grill.
Yes. Yes.
That's the only time you ever declare any shares.
And if I may go back, Commissioner, that is at the time we were planning on setting up the business. It was going to be under the corporate incorporated structure.
So, but that didn't materialize.
No, it hasn't.
I follow. Thank you very much for clearing that up. The last thing we need to cover just on your forms. If we look at 140, please. I think we're going back to the 2015
Yes.
Form. You're asked to declare land, and what you're asked is, do you have any land other than any home used solely for the personal residential purposes of you or your family? And you've declared one property or one piece of land in Mount Sage.
Yes, sir.
Now, was that your dwelling, or was that a separate piece of land?
That was a separate piece of land that I have since developed and am now living in.
I see. So if we go to 2016, which we'll find at 131. That's the same piece of land, is it? Sorry.
Yes, sir. And if I may, I may be jumping ahead of you, so you will correct me. On the 2nd of June, after reviewing these files, I noted and I wrote to the registrar that there was an error in the submissions of the parcel number. On most of them, I believe I wrote 111 when it should be 110. And the error was simply one that the initial 2 parcels of land were purchased by my wife and I, and one has been bought by my brother and his wife.
I see. Yes. But as of 2016, it was still
the block number. Sorry, not the parcel.
Yes, block. Yes, you're right. Well, that's on the record now. So, and you say you notified the registrar at this point.
That I submitted to the registrar, Commissioner.
Now, that's still as of 2016, if you like, undeveloped land.
Yes, sir. Up until 2020.
I see. So, well, if we go to 120 then and look at what you declared in 2017.
Yes.
Now you've got, this is 2017, and you've got, and you'll have to tell me if I'm making a mistake, but you now declare an address, a development property in Windy Hill, Totola, but you don't make reference to the Mount Sage property.
Well, the way it is written on the registrar lands, and this was around the time that I started, we started preparing to develop property. They just list the block and parcel number, and the location is in fact Windy Hill, which forms a part of the Mount Sage.
So it's in fact the same piece of land.
Yes, sir.
I see. So when we go to 109,
Yes, sir.
You've now, it's the same property.
Yes.
You've corrected the parcel number, but you've described it as dwelling.
Yes.
Was it by now, and I think we're in 2018 now, was it now your property? Were you living in it?
Just 1 second, Commissioner. I just want to ensure. Is this the date of 2020, Commissioner? This is the date that is received on 2020 for 2018.
It's received on the 2nd of June,
Yes.
2020.
Yes. So at that time, we had broken the ground for the land.
So it was still something that you had to declare because you
Yes.
weren't living in it.
Yes.
If you go then to 98, you've left it blank in your 2019 declaration.
Yes.
But if you go to 87,
it is filled in.
it's filled in there. Now, it's not necessary to. It's not. This isn't about going into the details of what's happened to one particular property, but it's about your understanding of what you need to declare in relation of land holdings that you have.
Yes.
Is this an example of an area where, in your mind, as the person who has to fill this form, there is any doubt or uncertainty about what you have to declare?
Not at all.
So you're aware of your obligations in terms of land ownership, is that
Yes,
right?
sir. Yes, I am.
Stepping back from the form, 2 points that you've made, Mr. Turnbull, is firstly that it's, or the main point you've made is that what you understood the purpose to be of this form is, and these are my words, to declare if you have any links or associations with government. So if, for example, if you have a business having a contract with government, then that should be something that you should be putting out in this form.
No, I believe that those are, I guess, as you said, those are your words. What I understood very early after being elected, it was to do with things relating to government. But as I studied the legislation and understood what was being asked and required of me, I understood that it was any interest that I have as a sitting member of the House of Assembly. And it extends to my immediate family as well.
And what do you define as immediate family?
For the purpose of this regulation and this piece of legislation, it would be for myself, my spouse, and or children.
And in terms, you said that it's your interests that you have to declare.
Yes.
If you go to 79 and just look at the preamble to the register, that describes the main purpose of the register of interest, and I quote, is to provide information of any pecuniary interest or other material benefit which a member receives, which might reasonably be thought by others to influence his or her actions, speeches, or votes in the House of Assembly, or action taken in his or her capacity as a member.
Yes.
Now, I now do not want to put words into your mouth, so that's why I'm going to ask you an open question. But
yes.
It is reading that, and you've filled in these forms over a number of years now.
Yes.
What do you take to be? With having that in mind, what do you take to be is the central obligation being placed on you as a member of the House of Assembly?
I believe knowing the culture and the society and the territory of which we live, I believe it is my position and my duty to report whatever businesses or interests that I may have and my family may have as it relates to me serving as a member, because in this society, in this territory of being a small knit society, there may be times going during my political career, it depending on how long I am allowed to be representative, that some of my interests might come into the position where we might do business with government or we may not. So for me, it is just going a step beyond what is required on the form, but just making it available to the persons or making it available to the registrar the interest that I have.
Now, you've described it as it's focused on yourself, your spouse, and your children.
Yes.
Is there a benefit to having a wider focus so that it brings in other members of your family who may have links with government?
There could be. I have not gone through all details of that, but they could be. It is possible.
If I could briefly move on, Commissioner, just to another topic,
Yes.
and hopefully we can take this shortly, Mr. Turnbull, but
No
because it's been the Commissioner has received helpful evidence on this from a number of members of the House of Assembly.
Okay.
And I just wanted to confirm that your understanding of the process is the same as theirs, and it is about allocation of assistance grants.
Okay.
As a elected member of the House of Assembly. Now, we have been provided yesterday, and this was, I think it came via Mr. Fingalstone Davis, but I think probably the initial source may have been the Honourable Neville Smith. But it's the guidelines for processing assistance grants,
Yes.
which is a 2-page document that has 17 paragraphs to it. Have you been issued with those guidelines as a member of the House of Assembly?
Yes, I have, sir.
And when were you first issued them?
I believe in 2015 when I was first elected.
Now, I'm going to try and summarize,
Yes.
I hope fairly, the process. An applicant can come to you to seek assistance. It is up to you to make an assessment of the merits of the application. But once you have done, if you approve it, it then goes to the Clerk of the House of Assembly. Ultimately, it then goes to the Treasury Department, who will issue the money if necessary, if appropriate. Is that the way it works for you?
I believe you have a good understanding of how the process works.
Now, there are instances, as we understand it, where the clerk to the House can effectively reject an application and send it back to the member, or indeed that it could come back with a query from the Treasury Department. Has
Yes.
either of those two circumstances arose in your case?
They have.
And what's been the next step in that situation?
But I must explain the circumstances.
Please.
For at least one or a couple of the times, it has been something simple as the date not being filled in, or the required documents, the identification or the complete submissions of the additional documents, supporting documents were not properly attached in some cases.
So relatively technical errors
Oh, yes.
are picked
Yes, sir.
up and sent
Yes, sir.
back to you.
Yes, sir.
But does it fall to you ultimately as the member? Do you have the burden of deciding on the merits of the application?
Well, definitely, Commissioner, because I represented the constituency, as I said earlier, about 3,500 persons. We are allocated as a backbencher just about $125,000 per year to deal with the needs of constituents. And those needs range from education to all the other things that have been put before you prior, especially after the hurricanes of 2017, and now specifically in this COVID era, where the district that I represent is specifically tourism driven, and my constituency for a large portion have been out of work for over a year. So the requests are are much more demanding. So it is a task. I wouldn't call it a burden, but it is a task trying to find ways and means to assist as many persons as possible, while at the same time having those that you will be unable to assist to the processes that are provided.
Other members have spoken about this, of a particular difficulty, and that is that the amount, and you don't get the full 125 at the beginning of the year, you get it in quarterly lumps.
That's correct.
But the amount that you have to work with is always much less than the number of requests that you're going to receive.
That is correct. My lawyer might challenge me on this one, but I just have to speak frankly. Because of my background in finance and doing money management and budgeting, I started in 2015 trying to assist persons within my community, understanding, trying to set up a budget. But the amount of requests that you have and the needs in the majority of cases are genuine needs that would not allow for me to continue that in all the situations. So it is always proven difficult that at the end of a quarter, you might be out of, even before the end of a quarter, you have exasperated your budget. And then at the end of the year, you're basically, telling persons, listen, I tried, but my budget is depleted and there's nothing I can do. I have to wait till next year. So the needs and demands on us as representatives trying to assist those needy persons in our community, those persons who are going through educational benefits and have their seniors in my community that I assist as well, who are unable to work and provide for themselves. So the needs are more than the resources provided, but I believe it is incumbent on me to use my discretion, to use whatever resources that I am allotted to help as many persons as possible.
Now, you've made the point that even before the quarter, the balance may be zero.
That is correct.
Now, if you reach the unenviable position where the balance is zero, and the next application is one that is obviously deserving, is it open to you to refer that person to another elected representative and to write a letter of support to that elected representative? That
is the case. Because I am indeed the district rep, there are 4 at-large candidates under the system that we have here in the territory of the Virgin Islands, that we try to get as much assistance as possible. So where my budget might be depleted, I try to refer to another member of that large team, or if it is a request that comes in from another constituency, I try to refer it to that particular representative.
Just to understand how the system works, is there anything to stop an applicant making an application to you as the member for one district and an application to a different member representing a different district?
Yes, in the same guidelines that you have provided, the checks and balances reside with the clerk of the House of Assembly and her team to ensure that there's not duplication, or if there's a need that arises that can be covered from the Department of Social Development and other agencies, that they be referred there.
And if someone in your district needs help, you can't give it because your balance is zero, as well as the territorial candidates, could they go to another district representative?
The individual?
Yes.
They can, once that representative is in a position to assist, they can. There's nothing stopping them from doing so.
Can I move on just to another topic, and that is it's again a question that we've asked of a number of honourable members, but it's about how Section 67 of the Constitution operates. Mm-hmm. You will likely, Mr. Turnbull, know it better than I do. But Section 67 provides that an elected member of the House of Assembly has to vacate his or her seat in the House in certain circumstances. And one of those circumstances, and I'm going to summarize it again, but it's essentially if they are in some way connected to a contract with the government of the Virgin Islands.
Yes.
Now, the Commissioner heard evidence, as I indicated earlier, from the Honourable Neville Smith, who explained the circumstances in which he came to be exempted.
Okay.
Because what the Constitution also provides, and I quote this, if in the circumstances it appears just to the House of Assembly to do so, the House may exempt any elected member from vacating his or her seat. Now, I am very confident that I can predict the answer that you will give to this question, but I think it is right for me to ask. Have you yourself ever sought and or been given exemption from vacating your seat under Section 67?
Absolutely not, sir.
Now, I mentioned the motion in relation to the Honourable Neville Smith, and that has particular circumstances to it. But in assessing how to vote on such a motion as an individual member of the House of Assembly, what information is provided to you in order to decide how to cast your vote?
Well, I believe, Commissioner, what I won't use the specific member, I just speak in general terms. On 2 occasions in this present House, maybe 3, motions have come for the Honorable House. So what is presented before us is the circumstances surrounding the members' involvement in a particular contract with a government department and ministry or entity. And we as members are given the opportunity to debate the merits of the position that is put before us, the motion that is put before us, and then at the end of it, a vote is taken. I remember on 2 occasions where and my position is and always will remain that the law, the Constitution provides for it, but it is always to rely and walk on the side of caution, because not because something is legal makes it always right. So my debate and my contributions to the 2 or 3 times that it has come up in this present House was just to ensure that members are aware of how perception is interpreted, and we have to be mindful that there are persons that view us as leaders, and it is just simple things sometimes that make it seem that we might be taking advantage of the laws and by and large the people in insurgency. So it is always a cautionary approach that I take, but I know, and I know the law, that it is in fact legal, and I debate in that fashion, depending on the 2 circumstances that I spoke about.
At the moment, you sit in opposition.
Yes, sir.
As an opposition member debating such a motion,
Yes, sir.
To what extent can you call for further information about a particular sort of contract that will be the subject of an exemption?
Well, as an opposition member during the debate or prior to the debate, I also sit as the member on the Public Accounts Committee. So we have the ability through that committee to call for additional information, whether it's from the Auditor General or the specific ministry or department, to understand the basis of the contract and how long it's been existing, just to ensure that what is presented is in fact factual, and then we do the debate. But for me, as I said before, it is about my principal approach to what is being presented and how it appears, how it looks to the public as an elected representative.
And this is just to understand the workings of the House, but if there is going to be such a motion for exemption,
yes,
and it's related to a contract, will that contract have come before the Public Accounts Committee before the motion gets to the House? Or can the motion just be introduced directly?
The motion can be introduced directly.
In that circumstances, what power would you have to ask for more information?
You would ask for it at the time of the debate. Yes.
So may I have a moment? Those are my questions, Mr. Commissioner. Can I conclude by, first of all, thanking Mr. Turnbull for coming to give his evidence today, and also thanking him for the way in which he has given that evidence.
Thank you, Commissioner.
And again, can I echo that? Thank you for your time. Thank you for your answers, and thank you for the clear way in which you've given your evidence.
Thank you, Commissioner, and thank you to everyone. And again, I stand by my statement earlier that the responsibility of what wasn't done in a timely manner is my sole responsibility, and I accept it fully.
Yes, thank you very much.
Mr. Commissioner, can I ask, I think perhaps for a 20 minutes lunch break, and then we resume?
Yes, as close to 2:05 as we can, Mr. Rower.
Thank you
very much. And I am. Yes, Mr. Wright.
Commissioner, our next witness due is Dr. Hubert O'Neill. Before we call Dr. O'Neill, may I raise one matter which came to the attention of the COI just after we adjourned for lunch. An article has been published online in Virgin Islands News Online, and its heading is COI document reveals turf war between ex-Governor Jasper and VI government. The article refers to a 33-page statement which was shared with our newsroom by senior sources within the Commission of Inquiry, COI. That 33-page document is a reference to the position statement that was filed and served with the COI on behalf of elected ministers on the 1st of June 2021. That followed on your invitation to a number of individuals and entities to file position statements on the question of good governance or governance and law enforcement and justice. Prior to that date, it had been shared with two members of the House of Assembly who are represented by Silk Legal. The COI was informed of that on the 1st of June 2021. It has not yet been published by the COI, and save with one exception, which I will come to now, it has not otherwise been provided to any other participant or individual or body. What has occurred, and this was with the agreement of the Attorney General, was that you directed that the position statement be shared with the Governor's office. And the reason for that was something that I highlighted at the directions hearing on Monday, which was that the content of the position statement had raised issues that firstly required obtaining further disclosure from the elected ministers, but also putting those who were the subject of their criticisms on notice of the content of the document. All those who receive documents from the COI in the accepted manner are bound by a duty of confidentiality to you as Commissioner. Insofar as it needs to be, that has been made explicit in the COI rules, but it is in any way a convention by which all legal representatives are used to operating in any forum. Since the article was drawn to our attention just as we adjourned for lunch, you and I, Commissioner, have discussed the content of the article and its reference to the position statement emanating from senior sources within the Commission of Inquiry. If I make clear that, leaving yourself aside, Commissioner, the COI team here numbers 5 people, including myself. Inquiries therefore have been made of all members of the COI team over the lunchtime adjournment. And I am satisfied, and I believe, Commissioner, you are also satisfied, that this document did not emanate from within the COI, or indeed from any source, however senior or junior. So I just wanted to set that out and put it on the record as to the steps we've taken in light of the article.
Thank you, Mr. Rowat. As you say, Mr. Rowat, this article has been brought to your attention and my attention during the short adjournment for lunch. Can I make this clear, that the substance of the leaked document will be the subject of this inquiry? In the document, the ministers make serious allegations that Governor Jasper and the United Kingdom government have acted improperly, unconstitutionally, and illegally, in the sense that they have acted against international law in respect of matters of governance. Contrary to speculation in the media and indeed by some of the participants in this inquiry, of course, I will investigate such criticisms. But the criticisms that have been made have to be investigated in the proper way. The Attorney General lodged the Minister's position statement on their behalf. The statement is signed by all 7 ministers. Both she and they have confirmed that they have no redactions that they would wish to make prior to its publication. I stress that this document will be published with any appropriate redactions as soon as I have received submissions in respect of what redactions need to be made. The position statement contains various personal information which the Attorney General has a duty to protect, as do I as a Commissioner. Furthermore, it contains information that the Attorney General has said may be confidential. She has indicated that those who may have the benefit of that confidence include the Governor and the United Kingdom government. That is why, Mr. Rawat, as you have said, I have directed that the position statement and its appendices be sent to the Governor's office so that he may make any submissions that he wishes to make in respect of redactions, both of personal data and other confidential information that he considers should be made prior to a determination by me and then publication of this document. Furthermore, I have also directed the Attorney General for legal submissions on the criticisms made, which I have not yet received. Yet further, as indicated in Monday's hearing, the ministers have failed to disclose the documents they have, which are on any view relevant to the criticisms which they make. I've directed them to make that disclosure to the Commission of Inquiry by tomorrow. They say that they will comply by Friday. These are matters which are due to be considered in the open hearings next week. As you've said, Mr. Rawat, over the course of the short adjournment that we had, you and I have caused inquiries to be made of the small COI team here. They were relatively easy inquiries to make because the entire team, save for the secretary, who's working literally next door, are here in the hearing room. I've received comfort, as have you, that the leak did not emanate from anyone in this team. To that extent, this article is simply wrong. But that means that the leak must have come from somewhere else. And it must have come from someone who owes a duty of confidence to me as Commissioner in this inquiry. I take that extremely seriously. It's unfortunate that the Attorney General is not represented at the moment. I think this is the first time, this is pure coincidence, I think this is the first time that she has not been represented at one of these hearings. But I direct the Attorney General and the Governor's Office, to whom this document has been sent in the circumstances that you and I have outlined, to write to me by 9 a.m. tomorrow with a list of every single person who has had access to this document and identifying inquiries that they have made to ascertain who may have leaked this document. I will once I've received those letters, make any further inquiries that I consider appropriate. But this Commission of Inquiry will be conducted on the basis of proper confidentiality with all of the participants and all of those who are engaged in this process complying with their obligations of confidentiality to the full. This inquiry simply cannot be conducted on any other basis. I know that the Attorney General is not represented, but if a message could be sent through to her and to the Governor's Office immediately, that those are my directions, an order will follow later today.
Commissioner, can I just, in terms of your direction, could I invite you to consider whether a similar direction needs to be made to Silk Legal, given that two of those they represented had access to the position statement prior to its disclosure to the COI?
The two individual members whom they represent, who we know have had access to the position statement because they've referred to it in their own letters confirming their agreement with it, indeed prior to us getting the position statement. In those circumstances, it's sufficient that the Attorney General tells us who she has disclosed the document to under her duty of confidentiality.
Yes, that would satisfy the point that I've raised.
And the direction, of course, will include any individuals to whom any individuals who have had access to it have disclosed information. It will, in that sense, have a waterfall effect.
Thank you.
Yes, thank you.
If we can return to the business of this afternoon, our first witness of this afternoon is Dr. Hubert O'Neill. And if I could ask if Dr. O'Neill is now sworn, please.
Yes, thank you.
Good afternoon. Would you like to swear an oath or make an affirmation?
Swear.
If you could take the Bible in your right hand and read what's written on the paper. Thank you.
I swear by Almighty God that the evidence I shall give shall be the truth, the whole truth, and nothing but the truth.
Thank you.
Yes, Charles.
Thank you, Commissioner. Dr. O'Neill, thank you for coming to give evidence to the Commission this afternoon. Can we start with some formalities that we need for the record? The first question is to ask you to give your full name, please.
Hubert Robinson O'Neill.
Now, normally, I would ask, for example, a member of the House of Assembly to give their professional address, but since you are now no longer in the House, I won't ask you to do that. What I will say is that, and this is something I say to all witnesses, in putting questions to you, I will try and keep them short and simple. It doesn't always work, but if you have any difficulty understanding a question I have put to you, please don't hesitate to ask me to rephrase it or to repeat it, and I'll then try again.
Certainly.
There are a couple of bundles in front of you, and we will need to go to them in due course, but not immediately. I'll take you to documents as we go along. Can I ask as well, just keep your voice up and speak slowly. And the reason for that is because, as you'll appreciate, we will need to make sure that we have an accurate and clear record of your evidence this afternoon.
Certainly.
Now, as I alluded, you were obviously at one point involved in politics, but you would have had a life before politics. And can I start by just asking you to give an outline of your professional background before you came into politics?
I am an ophthalmologist by profession. I've been in practice now for the last 28 years. I own a medical practice in Road Town, and I also do surgery at the Bougainvillea Clinic in Road Town. So that's been my life before politics, as a professional, as a doctor, an ophthalmologist, basically that.
Thank you. And turning to life as a politician, is it right that you were elected as the member for the 5th district in 2015?
No, the 9th
The 9th
district.
district.
That's
Give me.
of Virgin Gorda and Anegada.
Sorry, my fault. And which party was that for?
The National Democratic Party.
2015, was that the first time that you had stood for election?
No, it was not the first. I first stood for office in 1999, and subsequently, each 4 years after that, I had stood, but became successful in 2015.
See, and did you stand again in 2019?
Yes, I did.
But you weren't successful at that election.
Correct.
During the 2015-2019 period, the NDP was in government.
That's correct.
Did you hold any ministerial office during that House of Assembly?
Not initially. I was a backbencher at the time, but towards the last 6 months of the administration, I was promoted to Junior Minister of Tourism.
One of the issues and one of the reasons that we've not only called current members of the House of Assembly to give evidence to the Commissioner at this time, but also former members like yourself, is that of the Register of Interests. Now, that's governed by the Register of Interests Act 2006, which you may be familiar with.
Mm-hmm.
One of the questions that I have been putting to witnesses, and so far they've all been serving members of the House of Assembly, is the question of whether in principle it is a good idea that the Register of Interests be available to the public for inspection. And I wanted to ask you, as a former member of the House of Assembly, what your view is on publication of the register.
I think as it stands right now, it's not really available to the public.
That's right.
But in my opinion, just my opinion, really, I really think it should be. Because as a member of the House of Assembly, you have the obligation, you are charged with that obligation to make certain decisions in the interests of not only the government, but of the country as a whole. And there may be sensitive issues at times. And it could involve an entity, a project, or something that could involve some company or something that you have interest in, you personally as an elected member of the House of Assembly. So I personally think it should be published. I have no problems with that. Personally, I wouldn't, if I had to make a decision as a legislator about something, I would like to know that the public knows that I don't have an interest in whatever project that is or decision where it could in fact affect my decision making.
Now you expressed the view that your opinion is that it should be public. Yeah. How long have you held that view?
Maybe it happened when, this was some years back. This was from a previous NDP administration, which was back in 2003, I think it was, that an issue came up about the liberalization of the telecommunications industry. And there were two companies I know who were vying for, for licensing and so on. No, it was three companies actually that were vying for licenses. And the issue came up where one of the companies was owned by the BVI Investment Club, which happens to be a club mainly formed and owned by local individuals here in the BVI. And I think there were one or two of the sitting elected representatives at the time had shares in the BVI Investment Club. And it created a controversy because obviously the decisions that were made then involved those members. And from then I really thought it was pretty important that the public should know the interest that you might have in whatever, where it directly affects your decision making.
Was it an issue that whilst you were a sitting member of the House of Assembly that you ever raised within the House?
No, I didn't raise it. No.
Now, obviously, the register is a record of declarations of interest.
Correct.
We've received evidence that, that the House of Assembly operates by way of standing orders. In your time, 2015 to 2019, was there a mechanism, if something became before the House of Assembly, a debate, a motion that came before the House, either in total or when it's sitting in committee, was there a mechanism by which you, as a member of the House, had to declare an interest in the topic, in the agenda item?
As I don't know of any specific mechanism. However, I think it was on the discretion of the member himself or herself to make that disclosure to the House. But as there being a specific mechanism, I'm not sure that existed.
Or indeed a specific requirement on members to make that disclosure.
I don't know of that, no.
Now, I think when I used the phrase Register of Interest Act 2006, you nodded towards me. So it may be that you can still remember the obligations that were on you as a member of the House. If you don't, tell me and I'll remind you of it. Okay. But the requirement under the Act is that as a member, you are obliged to make a declaration of your interests on the date that you are sworn.
Correct.
You agree with that?
Yes, I remember that.
And then on every subsequent anniversary of that date.
Correct.
For the session of the House.
Yes.
And so if you don't do it by that date, you're in breach of the Act.
That's right.
Now, the second aspect of the Act that bears immediately on a member of the House of Assembly is Section 7, because that says, or 7A, says that if 3 months after the date, your due date, you still haven't filed your declaration, then you are again in breach of the Act, and the registrar is obliged to write a report to a standing select committee. Were you aware of that obligation?
Not directly. I was aware of the Act. I went through it, but I must admit I didn't go in detail as to the specifics of it. But if it had come up, obviously I would pay attention then, yes.
Now, I've referred to a committee, and during your time as a member of the House of Assembly, were you aware of the standing select committee charged with consideration of the Register of Interest?
Yes, I'm aware of that.
Can you remember when it was established during that session?
I can't say specifically what date, but I know it was within the first year of the administration.
Were you ever appointed to be a member of that committee?
Yes, I think I was on one committee to remember which committee now is the
well,
thing. I really.
So
It
what you
could
can
very well
say,
be the select committee.
you were appointed to a select committee, but whether it was a select committee concerned with the register of interest is something that you're
Not
not
sure.
quite clear about.
Not sure.
All right, well, I won't pursue that. Now, you have indicated that you were aware of the need to file declarations.
Correct.
Did you keep copies of your own declarations?
No, I didn't. I just went to the registrar and filled out the forms and left them with her. I didn't ask for copies. I would assume that she kept the copies confidentially.
If I could just show you, it's probably taking you back a bit in time, but show you take you through the declarations that you did file during your time as a member of the House of Assembly. Now, there should be to your left a file with your name on it.
Which one?
Is it not there?
No, I don't
if you
see.
give us a
I
moment.
have mine here.
You have your own.
Yes.
Well, that's even better.
All right.
That makes it a lot easier. So that's the file that was provided to you.
Okay.
If you go in that file to page 77, the first thing we're going to do, Dr. O'Neill, just to help you, is just look at the dates on the documents, because, and if I explain that the reason I'm going to ask these questions is because an issue that the Commissioner is interested in is how the system worked.
Yes.
And part of that will also be questions about your experience when you were a member in terms of how you approached the form.
Okay.
So if we go to 77, if I've got the right page, it's in fact, although it's stamped at the top, March 14, 2017.
Yes.
It is in fact your declaration for 2015, because if you go to page 87, that's the last page of the document. Can you just confirm to the Commissioner that that's your signature?
Yes, that is.
And underneath, is that your handwriting as well?
As well, yes.
And what you've written is 14th of March 17, and then
Yes.
you've added this declaration is for 23rd of June 2015.
Yes.
So it would follow, wouldn't it, that the required date was the 23rd of June 2015, but you had failed to make your declaration by that required date. Would you accept that?
Yes, I do.
And I remember I told you about the 3 months that then follows thereafter. Obviously, we're almost perhaps some 18, 20 months later. So again, you were way beyond 3 months, weren't you?
Yes.
Now, if you go, before I leave the document, now you've dated it on the date that you completed it.
Yes.
But you've also said that it's for the 23rd of June 2015. Was there? Did you receive any guidance or any advice as to how you should date the document when it was being sent in late?
The only guidance I got was from the registrar herself. And I think she's the one who suggested I do this as it's written there.
Well, if you go now to page, I think it's 66. This again is stamped. It's the first page of another declaration, stamped March 14, 2017.
Yeah.
But if we look at page 76,
Yes.
you've dated it, if we confirm that that's your signature,
Yes.
and you've dated it 14th of March 17, and then you've added this declaration is for 23rd of June 2016. That's right, isn't it? And so again, you'd failed to file on the due date, and you were beyond the 3 months, weren't you?
Yes.
If I take you now to 55 in the bundle, this isn't stamped, but if we look at page 65, it's again carrying your signature, isn't it?
Yes.
And it's carrying the date, the 11th of March, 2017.
July.
It's 11th of July, you're quite right. Now, 11th of July, 2017. So this appears to be your 2017 declaration. And it is it's again, not in by the date of the 23rd of June 17. It's
Yes.
a couple of weeks later, isn't it?
Yes, it is.
Now, if we look at 45, give me 44, please. Again, it's not stamped, but I'm going to suggest that you were, I think the election was in, I think, January 2019, was it?
It was February.
February. So this was the last declaration you made, which is actually for the year of 2018. And if you go to 54, again, this is the last page of the document. Does it carry your signature?
Yes, it does.
And the date underneath?
22nd of January, 2019.
And so that it was due by the 23rd of June, 2018. Yes. So again, you'd missed that date, hadn't you?
Yes, I did.
And you were outside the 3 months. Now, other evidence that the commissioners heard is that when the dates came up, when each year, in your case, when the 23rd of June approached, the registrar would write to members, yes, reminding them of the date and sending them a form. Was that your experience as well?
Yes, the registrar was sending me notices.
And that if you didn't, you didn't file your declaration in on time, she would then send you, if you like, reminder letters that you needed to comply. Did you receive such correspondence?
She did so.
Did you yourself have correspondence with the registrar at all?
Yes, I spoke to her on several occasions. I must admit to you, though, that when I was first elected, during the orientation and all of that, this declaration of interests was not a topic was even discussed during my orientation. So it didn't seem to be something of great importance at the time. And I must say I was tardy in following through with my declarations and so on. But I was aware, I became aware after the registrar kept sending me notices and reminders and so on. So I sought then to rectify it by, that's why you see those dates there that are changed, to rectify that. But if it was brought to my attention a bit sooner, I think I'd have been much more alert at doing the right thing at the right time.
It imposes a statutory obligation on you as
Yes,
a member of the House of Assembly, and the requirement to comply is on you as the member. It's not on anyone else.
Correct.
Now, the registrar was sending letters to as you've confirmed, telling people each year you have to do this by, in your case, the 23rd of June.
Yes.
Now, you said that it wasn't something that during orientation or at any point was considered to be important. Can you assist the Commissioner with this? Looking back now, what assistance would you have welcomed when you were starting out as a member of the House of Assembly in terms of obligations such as this?
Well, I think it probably needed to be emphasized much more at the beginning. I guess the authorities at the time, the clerk and the Speaker of the House, we had orientations with those individuals, but it simply was not mentioned, to be honest. It wasn't mentioned, but I think if some more importance was attached to it, I think we would have, I personally would have taken it a lot more seriously. I must admit to you too that I wasn't aware of the 3-month period there. I didn't read that section of the Act to know that you'd be in violation if you go 3 months over. I hadn't read that portion. But if it was more emphasized during the orientation, I think I would have been much better at it, at being forthcoming with it.
The Act, and why I asked you about the Standing Select Committee, sets out a mechanism by which, where you are, and there are different things can lead to a report to the Select Committee, but it's the possible sequence of events after a report is written is that, well, the mandatory one is that the committee meets to consider the report.
Yes.
But also that could ultimately lead to the matter being brought before the entire House of Assembly.
Correct.
Now, evidence that has been given to the Commissioner was that in the session where you were a member, the third House, where you were a sitting member, the Standing Select Committee met once. So far in this fourth House of Assembly, the evidence says it has yet to meet. Again, reflecting on your experience as a member of the third House of Assembly, would you think that if that your call that the matter be given more emphasis could be achieved by the Standing Select Committee being able to take a more proactive approach towards compliance?
It certainly needs to be more active. One sitting for a whole term really is not good enough. And it's not just that select committee, but other select committees suffer the same fate. They're just tardy in meeting and discussing matters. So yes, I think it's a failing of the House of Assembly, really, that these committees are not more active. They meet and meet regularly and act accordingly. that is a failing of the House, and it should be brought to attention, yes.
Can I now just turn to the second aspect of my questions, which is how you as a member approach the form, whether you, and really my questions are directed to your evidence as to whether you considered the form to be something that was useful and easy to complete. And if we do that by looking at one of your forms, if we go to the 2018 one at page 45. Sorry, 44, if we start there.
Yes.
That's your 2018 form. So it has a preamble, which if I direct your attention to it, Dr. O'Neill, it says the main purpose of the Register of Interest is to provide information of any pecuniary interest or other material benefit which a member receives, which might reasonably be thought by others to influence his or her actions, speeches or votes in the House of Assembly, or actions taken in his or her capacity as a member. I'm going to stop there. Now that's, if one likes, the opening sentences of this form. It's from the Act itself. The form is a schedule to the Act. Mm-hmm. When you read that, and you would have read it in the 4 occasions you had to fill in the form, but what did you take from that to be the main purpose of the register?
Exactly as it says. That it's important that the members' interests be known before a vote, or even giving speeches for that matter. It is important that the interest has to be known. So yes, I take it at its value. Right there.
If we, when you were completing the form, I mean, the form at various parts, and I can take you to them if you need reminding of it. They talk about your interest. It speaks of your interests. Yes. It also speaks of the interests of your spouse. Yes. And also your dependent children. Yes. Did you think, in terms of the information that you had to provide, that the form limited you in any way?
No, I don't think so, because it was explicit in the form. Not just myself, yes, of family members as well. So there was nothing wrong with that.
Now, you're speaking of family members. Did you, what did you, in your own mind, when you were filling in the form, what did you take family members to extend to?
Well, I take it to mean immediate family members. You know, my spouse, my wife, my children. That's about it. Immediate.
But would you take it as having extended to interests held by your adult children?
Yes, it does. I accept that.
And therefore, would it extend to if they had spouses? Would you think that would be a relevant matter to declare?
Would be as well, yes.
Now, if we look at your approaches, there are 10 paragraphs in the schedule. At page 45, you've set out there your directorships.
Yes.
And this is in 2018. You're asked whether you have any remunerated or unremunerated directorships, any company. And you set out Island Optic Limited. And you said in brackets DBA Totola Vision Center. Then you say optical retail and ophthalmology practice, Medicure Limited, and then Robinson O'Neill Enterprises Limited. Now, were those all companies that you were declaring?
Yes.
Now, when you came to remunerated employment, which is at 2 at 46, you referred to your private consultancy practice, but also that you were an ophthalmologist consultant at Peebles Hospital.
Yes.
That was a public aspect of your work, was it?
Yes, that's correct.
Now, if you, having looked at 1 and 2, if you go to paragraph 3 at page 47, what it asks is, does any of the paid employment registered in categories 1 and 2, so that's directorships and remuneration, entail the provision to clients of services which depend essentially upon or arise out of your position as a member of the House of Assembly? And it directs you to note 1, which says the services covered by this category include action connected with any parliamentary proceeding, sponsorship of meetings or functions in the House of Assemblies, building or offices, making representation to ministers, fellow members or public servants, accompanying delegations to ministers, and the provision of advice on parliamentary or public affairs. And what it also says is where you receive remuneration from a company or partnership engaged in consultancy business, which itself has clients, you should list any of those clients to whom you personally provide such services or advice directly or indirectly. Now, that's linking clients back to, if you like, your work or any work that you did or any activities you have which are not as a member of the House of Assembly. But when you read this and when you read it now, what information is a member of the House of Assembly, in your opinion, being asked to provide?
Well, I think it is asking you to provide information about your consultancies or any relationship that you have with these companies. And what remuneration are you receiving from it? I guess it's important seeing that being a member of the House of Assembly, and these companies that I've listed here might have some connection with the public service or the government itself. And I did list here the consultancy with People's Hospital, which is a public facility, as you know. So I think I was clear in declaring these consultancies.
If I can help with this, Dr. O'Neill, not particularly, my question is not particularly directed as whether you said the right thing or the wrong thing on the form, but how well the form was helping you to give information. Okay. Now, if one looks at paragraph 3, I'm going to suggest this to you, and tell me if you accept it or not. The purpose of it is to make sure that a member of the House of Assembly declares where they use their position as a member of the House to help a client. Mm-hmm. So, I'm going to give you a hypothetical, but if you had, if, for example, you were the director of a company that wanted to do business with government, and you were to use your position as a member of the House of Assembly to facilitate an introduction to a minister, that's the sort of information you should be expected to declare in this box, isn't it?
Yes, yes.
And you've agreed with me, but was that in your mind, do you think, when you were filling these forms in, when you were a sitting member?
Yes, I would say so, it was.
If we go to 48 and paragraph 4, excuse me. Again, keeping it general, the first question, and if I make clear for the record that on your declarations in relation to paragraph 4, your answer has always been no and was always no. Paragraph 4 is headed sponsorship. The first question it asks you is, did you benefit from any sponsorship before election where, to your knowledge, the financial support in any case exceeded in aggregate $2,500? It's a question I've asked of other members of the House of Assembly, but what did you understand sponsorship before election to mean?
I guess it would mean persons who are interested in your campaign and want to support your campaign by giving a financial, making a contribution to your campaign. The amount there of $2,500, I understand it's not to exceed that amount. I understand.
So, but does it, in your view, encompass donations? to your campaign?
Well, during my campaign, I did not have donors donating to my campaign of that magnitude. Smaller donations, yes. And it was not a great amount of donations. It was mainly from my own personal financial assets that my campaign was run. The party, the National Democratic Party, also assisted with the financing of my campaign partially. And the donations that I understand that came from the party was controlled by the senior members of the party. So I really can't say what those donations were, whether they were larger than the 2,500 or not. I really can't say. But indirectly, I may have benefited from it because I was being funded partially from the party as well.
Now, obviously, I've been taking you back to the 2015 to 2019. So you had stood in 2 elections, yeah. 2015 successful, 2019 unsuccessful. On those 2 occasions, so far as you were aware, were there any rules in place regulating campaign financing?
No, there were no rules.
There are no rules, you say?
Not that I know of, no.
And so I think, I hope I quote him accurately, but the Honourable Member Neville Smith said when we were asking him about this, you can spend $2 and lose, or $2,000 and win. And is it the case that there is no limit to how much you choose to spend on your campaign?
No, there's no limit.
I'm going to just quickly look through the other paragraphs on the form, and that's just so that we can have it on the record. In relation to, you're asked, as any member of the House of Assembly is asked, to declare gifts, benefits and hospitality above a certain level that you receive within the Virgin Islands. You have on your form said no to that. You were asked, and this is at page 50, Dr. O'Neill, to declare overseas trips. And these are trips as a member of the House of Assembly, which are not funded by yourself or from public funds. Yes. And again, you've said no. And you're asked about overseas benefits and gifts at 7, which is 51. Now, that's again, there's a threshold, but it's gifts or benefits that you receive from or on behalf of a foreign government, organization or person, which again is connected to your membership of the House. Now, again, you've always said no to that on your forms, but if we go to 8 at 52, you set out interests in land there, and you have given the same or similar details on different versions of your forms as we go through the year. But it's perhaps a wider question that I want to put to you. What interests in land did you understand you had to declare?
Well, the form is a general question here of what lands you own, what properties, etc., that you own. So I just listed practically all of the properties that I own in the BVI.
And did you include amongst them your own residential home?
Yes, it is. I did.
Because if we look at the top, you're asked, do you have any land other than any home used solely for the personal residential purposes of you and your family? But is it right that your approach was actually to go one step further and write down your own home as well?
Yeah, well, in addition to my home, I listed the others, which are really not developed. They're just bare land?
Yes. So, I mean, if we look through it, you've put Bath, South Valley, Princess Quarters. Is that I can't quite read your handwriting. A mountain in Tortola.
Butu Mountain. Yes.
Butu Mountain.
That's where my home is at.
Right, and then Hope Estate. You put 2 properties in Hope Estate, but effectively those were undeveloped plots of land that you own.
That's correct.
Then if I ask you at page 53, if we go to the next point, which is paragraph 9, shareholdings. Now you've put there shareholdings in 3 entities, but they were entities that, if we looked earlier, you'd also recorded in under directorships. Yes. So was it your understanding and approach that you might need to put the same information in different parts of the form, or refer to the same company or entity in different parts of this form?
No, shareholdings was, to me, meant holdings in companies, and which is what I listed there. Those 3 companies are my shareholdings. There was nothing different or otherwise that it meant, I think.
But my point is that you could have, if you take, for example, a company,
yes,
they could, your interest could have different aspects to it, couldn't it? You could be a director of the company, and you could also have substantial shares in that company.
Well, in this case, I was both director and shareholder.
And so from your perspective, you had to make sure, did you, that information was properly recorded in different parts of the form?
Yes.
And was that, where did that understanding come from, the form itself, or did you receive any advice about what you needed to put in the form?
No, I didn't get that advice. I just took it upon myself to list it and declare that, yes, I am shareholding in these companies and also director.
The last part of the form is at page 54. It's headed miscellaneous, and it reverts back to the preamble that I read out to you earlier when we started looking at the form. But it says, if bearing in mind the definition of purpose set out in the introduction to this form, you have any relevant interests which you consider should be disclosed, but which do not fall within the 9 categories set out above, please list them. Now you've left that blank. And again, I'm not asking about your particular interests, but it's more general than that. When you read that and when you read it now, what information did you think you would be required to disclose? What did you think it was targeted at?
I think that they were looking for information, say if something they didn't ask for previously, and specified in the question, that if there's anything that I thought would be relevant to my interests, that I should list them. I obviously didn't think of anything that was relevant here, so that's why I didn't list anything.
Now did you remember I asked you earlier about what did you mean by sort of immediate family? But do you think that question is directed at you alone and what interests you have, or does it encompass your family?
Well, how it's worded, I take it to mean it was me alone. I wasn't thinking of family, to be honest.
Yes.
I wasn't.
Thank you. Can I just move on to another topic? It's again a question I've asked of more than one member of the House of Assembly now, but it's about the operation of Section 67 of the Virgin Islands Constitution. And if I can sort of try and summarize it for you, Dr. O'Neill. What Section 67 governs is the tenure of seats of members of the House of Assembly. Mm-hmm. And it also prescribes that certain circumstances in which an elected member has to vacate his or her seat. And one of those circumstances is in subsection 3E, where it requires the seat to be vacated if, and this is a reference to the member, if he or she becomes a party to any contract with the government of the Virgin Islands for or on account of the public service, or if any firm in which he or she is a partner or any company of which he or she is a director or manager becomes a party to any such contract, or if he or she becomes a partner in a firm or a director or manager of a company which is a party to any such contract. Now, there's an exception to that, which is in subsection 7, that if in the circumstances it appears just to the House of Assembly to do so, the House may exempt any elected member from vacating his or her seat. Now, in your time as a member of the House, 2015 to 2019, were you ever exempted from vacating your seat under section 67?
Not me specifically. However, being a medical practitioner, I think on my team anyway, there were 2 other medical practitioners on my team, namely the Premier then, Dr. Smith, and also Deputy Premier, Dr. Pickering. We were sort of given an exemption because of our practice and our involvement in People's Hospital, the public hospital. So that exemption was extended to all of us as being consultants at People's Hospital. I think even in the past, there were other doctors who were elected as well. I can remember Dr. Scatliff was another one. I think he got special exemption as well. But yeah, just on that, we were given special exemption.
But was that an exemption necessary so that you continue working in a public service?
Essentially, yes. We're a small territory. We have number of professionals. However, take for example, I'm the only ophthalmologist here in the territory, and my services would be needed in the territory, both public and private. So I think it naturally follows true that I would have a special exemption.
Leaving aside that exemption, and were you, or did you, during your tenure as a member of the House, of the Third House of Assembly, were you ever asked to vote on a motion exempting another member from vacating his or her seat because they had a contract with government?
I'm thinking back. No, I don't remember being involved in that, no.
Commissioner, may I just have a moment?
Certainly, yes.
Commissioner, those are my questions. Can I conclude by thanking Dr. O'Neill for coming to give evidence, and also for the way that he has given his evidence this afternoon?
And again, can I add my thanks, Dr. O'Neill, for your time and your evidence and the clear way in which you've given it.
Certainly, it was my pleasure. Thank you very much.
Now, I think the next witness is not due until 4 o'clock.
That's right. We will. Our last witness of the day is Dr. the Honourable Natalio Wheatley. So, if I could ask you, Commissioner, to raise until Dr. Wheatley's here and we're ready.
Will do. Thank you very much. Mr. Howard, just before we begin, I know that the Attorney General wasn't represented at the first part of this afternoon, and I think that an email is on its way to her and the IRU. But have you discussed with Mr. Olympitis?
No, we haven't.
Right. An article's appeared in Virgin Islands online media, which says that the minister's position statement on governance has been handed to them by a senior sources in the COI. It's widely referred to in the article. That position statement is, of course, confidential. I've made inquiries, and Mr. Roberts made inquiries of the COI team, all of whom are here except the secretary who's next door. The leak did not emanate from us. Consequently, it must have emanated from one of two other sources, both of whom are covered by the duty of confidence. One is the Attorney General stroke the IRU, and the other is the Governor's Office, because with the Attorney General's permission, we sent the position statement to the Governor's Office because of the issues of confidentiality raised by the Attorney General herself when sending us the position statement, because others may have the benefits of a duty of confidentiality, including the Governor and members of the UK government. So I directed at the beginning of this afternoon that by 9 AM tomorrow, both the Attorney General and the Governor's Office make inquiries as to where this leak came from and identify every single person who's had access to the document, list them, identify the inquiries that have been made of them as to this leak, to identify the perpetrator of the leak. I take the breach of the duty of confidentiality extremely seriously. An email may already have gone to the Attorney General, it has, but I thought as you're here representing the Attorney General, I should mention that to you as well, Mr. Olympitis. Thank you, Mr. Rowett. Thank you.
Thank you, Commissioner. Our next witness is Dr. the Honourable Natalio Wheatley, who's here, and if I could ask if the Honourable Wheatley can be sworn, please.
And on the Bible?
Well, would you like to swear an oath or make an affirmation?
Affirmation.
If you could turn the piece
Yeah,
of
I
paper.
turned it around
Okay.
already.
If you could just repeat
Okay.
what's said.
Do I have to put my hand? I don't have to do the hand. on the
No.
Bible. Do I have to put my hand up in
No.
there or anything like that?
Not for an affirmation.
Okay. I do solemnly, sincerely, and truly declare and affirm that the evidence I shall give shall be the truth, the whole truth, and nothing but the truth.
Thank you.
Dr. Wheatley, thank you very much. Yes.
Thank you.
Thank you, Commissioner. Dr. Wheatley, thank you for coming to give evidence this
My
afternoon.
pleasure. My pleasure.
We need to start off with some formalities, the first of which is to ask you for the record to give the Commissioner your full name, please.
My name is Natalio Dixon Wheatley.
And your professional address.
At the Cricky Building in Rotown.
Now, as we go through, what I hope to do is to keep my questions short and simple. But if at any time you have difficulty understanding a question, please do tell me if you'd like me to repeat or rephrase it. There are a number of bundles on the desk in front of you. You don't need to open any of them at this moment, but we will be looking at some of those documents in due course.
Okay.
This may not present you with any difficulty, but it is something that we tell all witnesses, and that is to please remember to keep your voice up and to speak slowly so that your answers can be accurately and clearly recorded on the transcript of this hearing.
That's no problem.
If we can start off with a question that I have put to all members of the House of Assembly who've come this week, and that is if you could give the Commissioner, first of all, an outline of your professional background before you came into politics.
Immediately before being elected to the House of Assembly, I was a lecturer at H. Laverty Stout Community College for about 12 years. Before that, I was in London at school doing my PhD.
Now, is it right that it was in the 2019 election that you were first elected as the representative for the 7th district?
That is correct. Seventh district, yes.
And that was on behalf of the Virgin Islands Party?
Yes.
Was that the first time that you'd stood for election?
I stood in for election in 2015 with a party called the People's Empowerment Party, and also in 2011 with a party called the People's Patriotic Alliance.
Were you unsuccessful on those 2 occasions?
Yes, regrettably.
Now, in the 7th district, how many people live in that district?
I don't know. It's one of the bigger districts.
Now, you say it's one of the bigger districts. Minister Vincent Wheatley, who gave evidence yesterday, I believe, explained to the commissioner that there are boundary adjustments that are intended to try and keep the population within each district about the same.
Well, he would have been referring to registered voters. The boundaries would refer to registered voters.
I see.
But you have areas which have more people, and those persons may not be citizens or belongers of the BVI. So the district where I am is densely populated, and quite a number of migrants live there.
I see. Thank you. So you've referred to registered voters. How many registered voters were there as of the 2019 election in District 7?
To my shame, I do not know. Being a politician, that's something I should know.
Well, can I try and help you?
Please.
According to the official results that are published on the website of the government of the BVI, in that election in District 7, there were 858 votes cast. And you received 384 votes, which is 44.76%. Your nearest opponent received 338 votes, which was 39.39%. Does that accord with your recollection of the outcome of the election?
Well, I remember I won. I'll try to do better next time. Thank you.
Is that a yes?
Yeah, I remember that I won. I don't remember the exact vote total, but I do remember that I had more than the nearest competitor.
Yes, I think that follows from, I think, remembering that you won.
Yes.
And you were sworn in on the 23rd of March, 2019, weren't you?
Yes, that sounds familiar. Somewhere in March, yeah.
And were you immediately appointed to your ministerial position as Minister for Education, Culture, Youth Affairs, Fisheries and Agriculture?
I believe we had our ministerial appointments before we were sworn into the House of Assembly.
I see. And were you, I'm sorry, I interrupted you, please finish.
Yeah, I think sometime early in March, I believe. I could be wrong.
Was that at the same time that you were also appointed Deputy Premier?
Well, we had an unconventional system for Deputy Premier. Yes, I was the first minister appointed as Deputy Premier for a period of 3 months, and then other ministers followed. So I don't remember the exact date when I was appointed as Deputy Premier. I don't think it was the same date I was appointed as a minister.
I see. Are you still a Deputy Premier?
Yes, I was appointed permanently as a Deputy Premier sometime last year.
Thank you. Now, one of the, and you may not be aware of this, because I believe you've been traveling, which is why we moved your date for which you had to come and give evidence. But,
yes, and I thank you for accommodating me.
But one of the topics that we've been asking questions about and asking questions of members of the House of Assembly is in relation to the Register of Interest Act 2006.
Yes.
Now, the Act at the moment, and the Attorney General confirmed this, makes the Register of Interest itself private, in the sense that a member of the public cannot turn up and inspect it. There are measures pending that may change that. And what I wanted to ask you was what your view is of publication of the Register of Interest to the public.
Well, let me say firstly that I support transparency, and I support having proper checks and balances. Now, the question of whether the public has access to it versus another body, I think, is one that needs to be discussed more. But generally, I think if you have a competent body who can investigate possible conflicts of interest, that's something that I would support.
Can I ask you to develop that a little bit more? What do you think are the risks associated with the public being able to inspect the register of interests?
Well, I'm consistent on this, even as it pertains to financial services. We've had proposals for registers of beneficial ownership, which are open to the public. And certainly, I believe, even as legislators, you do have a certain level of privacy afforded to you. So same thing with beneficial ownership. I do think that we have a certain level of privacy. And if persons want to disclose certain things which might be considered to be private to the public, that's their prerogative. Me, for instance, I have no problem disclosing to the public my private interests.
Now, if you turn to the bundle, and it's page 1, please, in the bundle. There should be a bundle with your name on it, Dr. Wheatley.
108?
No, 1, just...
Page 1. Okay.
Now, this was a letter dated the 19th of February, 2021. And it was addressed from the Commission to all members of the House of Assembly. So it went to you as an elected representative rather than a minister. And it concerned details in the Register of Interests and the operation of the 2006 Act. If you turn over to page 2, the Commissioner asks that each member of the House of Assembly to produce 3 pieces of information. The first was the date and content of each declaration of interest you've made at any time. The second was, irrespective of any such declarations you may have made, the information or documents that you would provide in such a declaration of interest. And third, to confirm whether, if during your period of appointment as a member you failed at any time to comply with your obligation to make such a declaration, pursuant to section 3.1, in respect of each such failure, a full explanation as to why you did not make such a declaration. Now, focusing specifically on requests 2 and 3 and keeping those in mind, was there any reason you felt unable to reply to that letter?
That's an oversight on my part. I do apologize for not responding there.
But again, it's speaking from your perspective, leaving aside that you say it was an oversight, but in terms of providing that sort of information to the Commission, you did not have any difficulty in principle in so doing?
No, I don't have any problem producing it. And if I can share the information now, I would happily do so.
Things may have moved on, so it may be that we don't need you to do that.
Okay, well, that's convenient.
It is, but we can assess the level of convenience once we've had your answers to other questions.
Okay.
Let's look at your obligations. I can take you to the law if you want, but I just want to check your understanding of the obligations that the Register of Interest Act places on you as a member of the House.
Yes.
Section 3 requires each member of the House of Assembly to make a declaration on the date that they are sworn. So in your case, that was the 12th of March, 2019.
Yes.
Were you aware of that obligation?
12th March
2019.
when I was sworn into as a minister?
No, as a member of the House.
Okay, so the 12th was when we were sworn in?
Yes.
Okay, yes, I'm now aware of that.
You say now aware of it. Were you aware of it on the 12th of March, 2019?
I don't remember. I actually don't remember. And I don't remember it being mentioned in any orientation or any persons in authority telling me. But I do know that the Registrar of Interests at some point, I don't remember the dates, started writing to us and reminding us of our obligations.
Well, you're not the first witness to discuss the correspondence with the registrar. So can I come back to that in a moment?
Sure.
Now, that's the obligation that's imposed on you on the day you're sworn.
I recognize that.
Yes. Now you say you weren't aware of it at the time. When did you become aware of it?
I wouldn't be in a position to give you exact dates, but when the registrar of interest began writing to me, I certainly would have been aware at that point.
That you had a statutory obligation to fulfill?
Yes.
Now,
forgive my ignorance on that.
Well, can I take it in stages again? But the obligation is also to make a declaration on every subsequent anniversary. Are you aware of that obligation?
Yes, I am aware of that.
So then the obligation rises again on the 12th of March 2020, 12th of March 2021, doesn't it?
Yes.
Again, when did you become aware of that obligation?
Oh, that it repeats?
Yes.
Perhaps I was reminded of the obligation when the registrar of interest began writing to me in the subsequent year.
Now, let's deal with the correspondence from the registrar. So other members have given evidence that they would receive, in advance of the date when they had to submit a declaration, a letter from the registrar reminding them of their obligation. Did you receive such correspondence?
I cannot confirm that I opened the letter and read it before the date. I may certainly have received it, but I have a backlog. I can show you my desk at my office if you like. It's quite embarrassing, but I have quite a number of requests dealing with a number of things under my very large portfolio. So it could have been the case that I did not open the letter until after the date.
And obviously, when you first opened it, that's when you would have become aware of your obligations under the Act.
Yeah, perhaps be reminded, certainly because, you know, with all the pressing issues that we have to deal with, pandemic, hurricane recovery, everything else under the sun, it's quite easy to forget.
And other members have also confirmed that they would have received what may be described as chaser correspondence from the registrar, reminding them that they may have missed the declaration date. Did you receive such correspondence from her?
I do remember receiving at least one letter saying that I've missed the date.
Now, some of, have you retained the correspondence that you received from the registrar of interest? I appreciate some of it might still be on your desk unopened, but have you retained it?
I actually requested correspondence from the registrar of interest.
Is that copies of the correspondence that they had issued?
Copies, yes.
When did you make that request?
Recently, when I declared my interest this year.
When you made your 2021 declaration?
Yes.
I think, and I'll be corrected if I'm wrong, but I think the date of your 2021 declaration is the 13th of June, 2021.
That's correct.
Was that at the time that you made the request for correspondence?
Yes.
Have you received the correspondence?
Yes, I haven't really examined it too much in detail, but I received it.
Would you be willing to provide copies of what you received to the Commissioner?
Absolutely.
Thank you. Well, I think I'll pause there, Commissioner, and just make that not necessarily a piece of homework for you, Dr. Wheatley, but perhaps for Mr. Olympitis, if he can coordinate providing that correspondence to the Commission, that would be helpful.
Absolutely.
Now, another obligation that arises on members. Well, firstly, if you don't provide your declaration on time under the Act, you are in breach. But a second way in which you can be in breach is if within 3 months of that date, you still haven't filed the declaration, then you are again in breach. Okay. That's under Section 7. Were you aware of that at all?
No, I was not.
And is that still the case today?
Well, I'm aware of it now.
Yes, but this is something new that I've told you, is it?
Yes, this is the first. Well, I have to admit, I watched a hearing before this. I'm not sure if that's cheating, but I watched a hearing before this and I became aware of it then.
Did you not know about the Section 3 obligation to make it's a mandatory statutory obligation to make a declaration on the anniversary of your taking up your appointment as a member?
No, I think I answered that. The part that I was not aware of is this 3 months you spoke about.
Yes. Thank you. Yes.
The 3 months specifically you're referring to.
Yes, and if you're caught by that, the registrar is mandated to write a report to a standing select committee.
Okay.
Are you aware of the existence of a standing select committee charged with considering the register of interest?
Yes. Yes, I think through your questioning that has become a hot topic.
So again, is that something that you've learned through watching the commission's proceedings?
Yes, it's very interesting watching, I might say.
Now,
very informative.
On the other members who have given evidence have identified who they believe sit on that committee, which is chaired by the Premier. You're not a member of that committee, are you?
No, I'm not.
And if you are not a member of a committee in the House, does that mean that you wouldn't necessarily be aware of any of its activities?
Well, of course, if a standing select committee makes any reports to the House, I might know about it, or perhaps maybe if there's a notice of a meeting of a standing select committee to other members, I might know about that.
But otherwise, it would be just the committees in which you're actively involved that you would be concerned.
Yes.
Right. Could we turn in the bundle that's addressed that's for you, Dr. Wheatley, to if you give me a moment. To page 54, please.
Page 54.
I just wanted to check some dates with you, if that's all right. Now, if we're both on the same page, that should be the first page of a declaration of interest form, and it's got a stamp from the Registrar of Interest at the top there, and in manuscript is written the date 6th September 19. Do you have that, Dr. Wheatley?
6 September 19, yes, I do see that.
It's got your name at the bottom. Is that in your handwriting?
That is my handwriting, regrettably.
Yes.
Not that pretty.
No. If you then go, please, to page 64.
64.
I'm going to take you to the last page in the document.
Yes.
Can you confirm that that page carries your signature?
That is my signature.
And underneath in manuscript is the date 3rd September 19. Is that in your hand?
Yes, that is my handwriting there.
Now, as I explained, you would have under the Act, you had an obligation to file this by the 12th of March 2019.
Yes.
And so because you didn't do that on that date, do you accept that you were in breach of the Act?
Absolutely, in ignorance, yes.
And then, as you learnt from watching the Commission's proceedings, there was also the requirement that you provided, that the 3-month deadline, additional deadline that we've been speaking about.
I missed that as well.
You missed that as well.
Yes.
So again, you're in breach there.
Yes, it's not something I'm proud of.
If you go to page 43 then.
Yes. 43. I'm here with you.
Thank you. If you look now, this is another declaration form. It's stamped again by the registrar. In manuscript is the date, the 10th of June 20. Do you have that?
Yes, I'm getting better. Perhaps next year I'll be on time.
Well, let's take it in stages and we'll
Yes.
see where we are. If you go to 53.
Yes.
That's the last page of the document. Again, is that your signature?
That is my signature.
In typescript underneath is the date 2nd of March 2020.
Yes.
Can you explain the difference in dates? Because it seems to have been dated 2nd of March and that would be the date when you signed it.
Yes.
But then reached the registrar on the 10th of June 2020. Do you have any explanation for that?
It may be that I completed it on March 2nd, but did not submit it for whatever reason. Perhaps maybe I thought I submitted it and I didn't. Yeah, that could be the case. I'm just assuming,
Right.
because I don't quite remember.
Yes, but what we can say is that at least it reached the registrar.
I accept that,
If you go now,
but no intent to be dishonest.
no one is suggesting that you have any such intent.
Okay, just for clarity, I want to make sure no one even has the inkling in their mind.
Let's go to page 65.
Okay, good.
This has been produced today, and it's your 2021 declaration.
It produced to the commission today.
Yes.
Yes.
Well, I think the reason is that the commission had prepared its bundle for you before the 13th of June,
Yes.
2021, which is the date that the registrar stamps as having received it on that first page.
I certainly understand. So it would
And
not
if
have
you-
been included in the bundle before.
If you go to page 75,
Yes.
again, can you confirm that that is your signature?
Yes.
There's a manuscript date underneath, 13th of June, 2021. Is that in your hand?
That is certainly my handwriting.
Now, again, you've missed the 12th of March date, haven't you? This year?
Yes, I have.
And you are outside, perhaps just by one day, the 3 months, aren't you?
April, May, June. Yes, you're quite right.
So
Is it 3 months? Because some months have 31 days. You're aware of that.
well, perhaps we don't need to
Is
get
it
into-
90 days? Perhaps we can count.
Well,
90
I can
days.
take you to the Act if you wish. Would that help you?
3 months?
Well, would you like me to take you to the Act?
Well, I accept that since these have been filed, that I have been in breach of the date anniversary of my being sworn into the House of Assembly, if that's good enough.
Well, let's go and take a look at the Act.
Okay.
There should be another bundle there called Constitution and Legislation Bundle.
Yes.
If you go to page 59,
Page 59. Yes, I'm here. Page 59.
that's the first page of the 2006 Act.
Okay.
If you go through to page 64,
Yes. Registrar's report.
I'm going to read out to you 7A. Where a member fails to make a declaration within a period of 3 months from the date on which the duty to make that declaration accrued, the member shall be in breach of the provisions of this Act, and the registrar shall, within 14 days of the knowledge of such breach, submit a report of such breach to the committee, which shall meet to consider the report within 21 days of its submission.
Yes.
Now, whilst I want to just be clear what you are accepting you may be in breach of. Now, you said in relation to certainly your 2019 declaration and your 2021 declaration that you missed the 12th of March date. That's right, isn't it?
Yes, I missed that day.
And you've also said in relation to your 2019 declaration, which was signed on the 3rd of September 2019, that you have missed the 3-month outline deadline. that
Well, I
I've
did
drawn
say
your
we have
attention that.
to, if 3 months is interpreted as how many days?
Well, it's 3 months. If it's 90 days, I think you're out by more. But this says simply 3 months.
3 months. So it depends on how we interpret 3 months, but I don't want to get caught up on that point.
Well, 3 months is just not 6 months, is it? That's what the problem was. I mean, you were 6 months.
Oh, I'm talking about this last one that we had here.
I'm talking about 2019.
Yes, okay, 2019, yes, I was in breach of that. That's clear.
And then in 2021, it says 3 months. Now you've filed it on the 13th of June, 2021. Do you accept then that you are in breach of Section 7?
We'll have to check that. We'll have to check in terms of, how we interpret 3 months, but I don't see it being necessary to get hung up on that.
Well, it's important, Dr. Wheatley, for us to recall what you're happy to accept as a breach and what you're concerned to accept as a breach. And if you're not comfortable in accepting that you may be in breach of Section 7, please do say so.
I can say to you very clearly that many members, including myself, have been in breach of the provisions of this Act. In some instances, ignorance, and something that I would endeavor to correct moving forward.
Because if you are caught within the 3 months in relation to your 2021 declaration,
yes,
your expectation shouldn't it, that the registrar should now write a report about your breach to the standing committee?
And an important point that I'm pretty sure you're aware of is that the registrar of interest was hospitalized. Are you aware of that?
The new registrar of interest has been hospitalized.
No, the one that preceded her. She only started recently.
Yes.
This new one, she started after the date where it was sworn in.
We did know that the previous registrar was unavailable for a time.
Yes,
but that's not
a significant portion of time.
No, we understand that.
Yes,
but that's not the point Mr. Rowett's making. Under Section 7, Section 7 is this is a statute of the House of Assembly.
I accept that,
and so the provisions of it are important.
Yes, I do agree with that.
Under Section 7, the
yes,
registrar will have to work out what 3 months is, because if you were over 3 months in complying, she's mandated, she hasn't a choice, she has to report to the standing committee.
Yes, yes, I accept that. I certainly do accept that.
If I could just pause here, just to ask you to do one thing, Dr. Wheatley, and that's just to speak a little bit more slowly. It's very important that we don't get into a situation where we're talking across each other, because otherwise your answers won't be recorded.
Okay, I can speak more slowly.
Thank you very much. Can we look just at what you did declare? And we'll use your 2020 declaration for that. So if you go to page 45.
Page 45.
Let's start at page 43, please.
Page 43.
Yes.
I'm here with you.
Now, this was the second declaration that you filled in. And so by this time, you've had the experience of filling in one declaration.
Yes.
You will have had correspondence from the registrar of interest. That's right, isn't it?
That's right. Keep in mind 2020 is during the pandemic. I think that's significant. Okay, go ahead.
Yes.
Sorry to interrupt.
I think the questions I hope to put with you are not pandemic based. So let's look at the main purpose of the Register of Interest.
Okay.
Now, the main purpose of the Register of Interest is given in this form as, and this is also in the Act, is to provide information of any pecuniary interest or other material benefit which a member receives, which might reasonably be thought by others to influence his or her actions, speeches, or votes in the House of Assembly, or actions taken in his or her capacity as a member. I stop there. Now, when you read that preamble, and you filled this form in 3 times now, what did you understand to be the purpose of the Register of Interest?
It seems clear there. It states it right there. To provide information of any pecuniary interest, or other material benefit which a member receives, which might reasonably be thought by others to influence his or her actions, speeches, or votes in the House of Assembly, or actions taken in his or her capacity as a member. That seems pretty clear.
And so when filling it in, would you agree that the member has to have in mind what could reasonably be thought of by others?
Yes, I mean, that's certainly subjective, but yes, there has to be some type of interpretation there.
Now, if we go through the form as you completed it, and your answers are in greater part the same throughout. So you have declared that you hold no directorships, is that right?
That's correct.
You've also declared, and this is at page 45, that you have no remunerated employment, office, profession, etc., other than your membership in the House of Assembly or ministerial office. Is that right?
That is correct. My only job is to serve the people.
At 46, which is linked a question, paragraph 3, which is headed clients and is linked to the answers you give in 1 and 2, you've again recorded that as no.
No.
Now, if you go to paragraph 4 on 47, you were asked there, did you benefit from any sponsorship before election where, to your knowledge, the financial support in any case exceeded in aggregate 2,500? So the question to you here, and you may wish to remind yourself of the guidance that is given at the bottom, particularly at note 2.
Note 2?
Yes.
You should register money given to you by your election campaign committee and money spent by your election campaign committee in connection with your election with your permission.
Now, you've answered no to that question. What did you understand the phrase sponsorship before election to refer to?
A contribution towards my campaign, a financial contribution or otherwise.
When you say otherwise, can you give some example of what otherwise captures?
Perhaps in-kind contribution.
And when you say a contribution to your campaign, do you mean donation?
Monetary donations or in-kind donations.
And so in terms of how the 2,500 operates, would your understanding be that if 10 people gave you $2,000, then you wouldn't have to declare those, but if one person gave you 20,000, then you would have to?
Can you repeat that again, please?
Well, if you read 4A, it says financial support that exceeded in aggregate 2,500. So if somebody gives you 2,600, you would have to declare that, wouldn't you?
That's my understanding there.
But if the example I was using is if one person gives you 20,000, you would have to declare it because it's over the 2,500 limit.
Yes.
But if 10 people give you 2,000, you wouldn't have to declare that, would you? Because that's under the limit.
It says here in aggregate. So if there's a one-time donation of 2,000, no.
Yes. If the same person then comes along and gives you another 2,000.
Yeah, then I would have to declare that.
But if 10 different people give you 2,000, you wouldn't have to declare any of that.
No, a small contribution. It wouldn't have to be logged.
Now, this is a question that the Commissioner raised first with the Attorney General, but it's been asked of other members of the House of Assembly who've come to give evidence, and indeed former members. Are you aware of any regulations that govern how much money you can spend during a campaign?
No, but it's something that has been in discussion in terms of election reform.
Sorry, in discussion by whom, Dr.
There was a committee for election reform.
A committee established by whom?
Deputy Governor's Office. No, I'm sorry, by Cabinet.
Are you speaking of the current cabinet?
Yes.
Established a committee.
Yes.
So since you came into office in 2019, you've now established a committee to look at electoral reform.
Yes, we had a committee. and a report was made.
Right. So the committee is no longer in existence, is that right?
The committee has completed its work.
Who sat on the committee?
I sat on it. The leader of the opposition was on there. We had the elections office director, and there were perhaps the Solicitor General, member of the private of the community, Mr. Jamal Smith. There may have been some other persons who I can't remember right now, and the deputy governor was on there as well.
And so this was, just so that we're clear, it was a committee established by cabinet.
I want to say yes.
You want to say yes, but is there a but there? Is it a yes or no, or you're not sure?
Would you, I could check and be sure.
But
I'm sorry, Mr. Roberts. To whom did this committee report? Once the report was done, because you said that the business was done, the report was prepared. Who was it?
Well, it's for the consideration in some instances of the House of Assembly.
But has it been given to the House of Assembly to consider?
Yes, a presentation was made to the House of Assembly.
when was that presentation made?
Sometime earlier this year, I believe.
And so, how soon after you entered government was the committee set up?
I cannot say.
Can you remember attending meetings of it?
Yes.
Were they in 2019?
I think it was after then.
After that is 2020. Were they in 2020?
It was either in 220 or 221.
So if it's
we had multiple meetings.
So if it's either 2020 or 2021, does that suggest that it began in late 2020?
I would prefer to get the dates as opposed to giving you incorrect information.
Well, again, if we could ask you to confirm the date at which the committee was set up and the date at which it issued its report.
I can do that for you.
Thank you. Well, I think Mr. Olympitis is making a note of that so he can remind you of it.
Thank you. Reminders are important.
Yes, no, they are.
Yeah.
And the report too.
Yes, I don't have a difficulty with that. I don't think anyone will have a difficulty with that.
Thank you.
All of these matters are matters which have been discussed in the society for a while, as they should be. These are important issues.
Thank you, Dr. Wheatley.
If we then return to the form, we were on page 47. You going through it, and just to record for the transcript your answers, and this is your answers across 3 years of forms, that you've recorded that you've received no gifts, benefits or hospitality in the Virgin Islands, and there is a threshold above which you would have to declare it, but it relates to receiving gifts, hospitality and benefits as a member of the House of Assembly from any company, organisation or person within the Virgin Islands. You've said no to that.
No.
You also, at paragraph 6, which is at page 49, in relation to overseas visits, you say, you record that you've had no overseas visits, but if you look at, say, for your 2021 declaration.
Can I interrupt you?
Of course.
I'm sorry about that. I didn't say that I had no overseas visits, but I had no overseas visits relating to or in any way arising out of my membership of the House of Assembly, where the cost of the visit was not wholly borne by myself or by public funds.
Yes.
Okay.
That's what you're asked to answer in paragraph 6.
Yes, and I said no.
You said no in 2020. You also said no in 2021. But if we look at...
no, actually in 2021.
Yeah, you're right. You said no in 2019,
Yeah.
no in 2020. If we go to page 71.
Yes. Yes.
There in your 2021 declaration, you've disclosed a visit to France in November 2019.
Yes.
And that appears to have been partly funded from the public purse. If it had been wholly funded, you wouldn't have had to declare it, would you?
No, well, actually, this provision was a bit unclear to me. So if you notice, it's referring to 2019.
Yes.
So in 2020, that should have been in the declaration.
Should have.
But based on my interpretation, it did not need to be. But I had a conversation with the Registrar General, and she suggested I put it for safety. But now I believe I have a better understanding of this provision, and I don't think it should have been listed at all.
Now, it's helpful that you indicate you have a better understanding, but when you came to look at it, what is it about the wording of paragraph 6 that in your view causes uncertainty or doubt?
Well, I thought it was saying perhaps if I took a trip and I used my own funds and I used public funds. For instance, I was accompanied by my wife. So I paid for her plane ticket myself and all her expenses myself. Well, my expenses, my plane ticket, my hotel, all of that was taken care of by public funds. So I thought it was referring to that. But now I understand that this means whether I took an overseas visit that was funded by someone besides myself and besides public funds. Like for instance, a friend of mine or someone who supported me politically or something like that. That's now what I understand this to mean. So it was a misinterpretation.
And also what is important to record, isn't it, that it's if you're taking an overseas trip in a way that arises out of your membership of the House of Assembly. I mean, obviously, if a generous friend wishes to send you somewhere, that's a matter between you and them, isn't it? But if somebody wishes to send you as a member of the House of Assembly and fund your trip abroad, that's something you would have to declare.
Yeah, that's problematic and certainly would have to be declared.
Now,
I accept that.
You've had further clarification about what you should or should not put in this paragraph. You declared it in your 2021 declaration, having spoken to the registrar.
Right.
You've now formed the view that you actually needn't have done so. Where has your further clarification come from?
Speaking to a lawyer. Yeah, I spoke to a lawyer about it.
Any particular lawyer?
I don't want to disclose the lawyer I spoke to about that.
Fair enough.
Do I have to mention
No,
that?
not at all. It's all right.
Okay.
If you go then to paragraph 7, we can stick with 72 if that's more convenient to you, because it's the same paragraph. But you're asked there as a member of the House of Assembly to declare overseas benefits and gifts, and you've said no on every declaration, haven't you?
Yes.
And then in relation to land, which for some members has caused some confusion, what do you think you're expected to declare in under paragraph 8?
Any land other than where I reside.
So are you quite looking at it? Do you think it makes clear that you don't need to declare your personal home?
Yeah, I think that's clear here. It says other than any home used solely, word there, for the personal residential purposes of you and your family.
Now, in your 2021 declaration, having previously said no to this, you have said yes. And what you're asked to do is to indicate below the nature of the land, and then give the registration section, block and parcel number, and the street and number if appropriate of the land in each case. What you've written is intended to be commercial, and then you've set out a block and parcel of land in, is it Long Hook?
Long Look.
Long Look.
Yes, specifically Fat Hogs Bay.
Now, just again, because of the way you've written it, that's so that we're clear, it refers just to one piece of land. Is
just
that right?
one piece, one small piece.
Now, if I take you to para 9, we can stick with your 2021 declaration, 74. There's a requirement to declare shareholdings, and you said no, so you don't have any shareholdings of any sort. Is that right?
I don't.
And neither does your spouse. I mean,
No.
And you're also expected as a member, if you have dependent children, to declare if they have shareholdings.
They don't.
And you're looking at this. Is it as in terms of an explanation or the request of what you have to provide? Do you feel that there is any uncertainty or ambiguity about the wording?
Let me read it again just to make sure. Do you have, either yourself or with or on behalf of your spouse or dependent children, interest in shareholdings in any company or body which has a nominal value A, greater than $25,000 or B, less than $25,000, but greater than 1% of the issued shares capital of the company or body? Less than 25,000, but greater than 1%. I think that's clear.
In your case, you've always answered that no, as you just said.
Yes.
The last paragraph in the form is headed miscellaneous. And if you've got it, it's page 75.
I got it.
It says, if bearing in mind the definition of purpose set out in the introduction to this form, you have any relevant interests which you consider should be disclosed, but which do not fall within the 9 categories set out above, please list them.
Okay.
What did you understand the purpose of paragraph 10 to be?
To capture anything that the form might have missed, and someone thought perhaps the public should know about as it pertains to a pecuniary interest.
And who do you think it's directed at in particular?
I think it's directed at members of the House of Assembly.
Well, there are various parts of the form that are directed at a spouse or children. So I'll ask you the question again. Who do you think it's directed at?
I think this is directed at members of the House of Assembly.
And so it means that you don't feel an obligation to declare any other sort of interests that don't fit into the other categories, but are held by, for example, your spouse.
I do think you have to disclose interests by your spouse. I think that's clear from the purpose of this. Let me read the purpose again. To provide information on any pecuniary interest or other material benefit which a member receives, which might reasonably be thought by others to influence his or her actions, speeches or votes in the House of Assembly, or actions taken in his or her capacity as a member. So this doesn't refer to spouse, so perhaps it's just a member of the House of Assembly.
You say perhaps, Dr. Wheatley. Earlier you were a little bit more certain because you said twice that it's directed at members of the House of Assembly.
Yes.
Does it follow that if a member's spouse had an interest that did not fall into any of the other categories, but could lead someone reasonably to think that it might influence the conduct of that member, the member wouldn't have to declare it in paragraph 10?
Well, based on the purpose, no, but out of abundance of caution and adhering to the spirit of what this seeks to do, it should be declared. But just in a strict black and sense legal sense, no, because the registration form and the main purpose of the register of interest, it only mentions members.
Now, you said abundance of caution. Of course, different members, individual members may act with a different degree of caution. So does it follow that this is an aspect of the form that may be inadequate?
Well, if we want to make it clear that we want spouses' interests to be declared under a provision like 10, then it would have to be revised.
Do you think having filled in this form 3 times, that, but also having, I think, voted for the amendment to the Act that allowed a commission of inquiry to access to the register?
Yes.
Looking at all of that, do you think that the format of this form is something that needs to be revisited.
I think so. I would agree with that.
May I move on to a different topic, please, which I hope we can deal with briefly, because we have had evidence on it from other members of the House of Assembly. And
Certainly.
the way that assistant grants are distributed by elected representatives.
Yes.
I'm going to try and summarize the process and ask you whether or not you agree with it, and that's based on the evidence that's already been given. As we understand it, and the evidence is that as a district representative, you would, under normal circumstances, receive through the course of a year $125,000, which can be given in assistant grants.
Is it 125 or 120?
125.
Okay. Okay.
Are you not sure of how much you are given each year?
I thought it was maybe about 30,000 a quarter, but I'll go back and check that.
Do you actually keep records of how much you distribute each quarter?
I distribute all of it, I guarantee you. Whatever it is.
You keep records of what you distribute?
The club has a responsibility of keeping those records.
So you yourself don't keep any records?
No, not outside of what the applications that go to the clerk. You mean if I make my own copies, etc.?
Yes.
I don't make copies of the applications.
And you don't keep a record of where a certain amount of money goes to and to whom?
Just the clerk. If I need information, I can request it from the clerk.
So you're
there's an electronic. Of course, all of these things are handled electronically. And if I need any information, I can always request it from the clerk.
Minister Wheatley told the commissioner that, and that's Vincent Wheatley, he told the commissioner that what
I've
he
noticed
does.
you've been referring to Minister Wheatley
Yes.
a lot, so you have to distinguish between us.
Well, I can distinguish by calling you Dr. Wheatley.
Okay, thank you.
He hasn't had the benefit of that title yet, but what he told the commissioner when he gave evidence was that what he does is publish on his website a list of how he has allocated the money that he's been given to use by way of assistance funds. Is that something that you do?
I wouldn't necessarily publish on a website, but I usually have a meeting where I discuss all my programs that I've administered for the year. And I may mention specifically the amount of grants I've given. I'll have to review my speeches, but I certainly make reference to in a meeting that I seek to have at least once a year, reviewing the activities for the year.
Now, you referred to programs.
Yes.
The evidence that we've received is that the money that you're given, you have to use for a range of purposes. So,
yes.
For example, immediate medical needs or welfare needs. People can make applications to you as an elected representative.
Yes.
But also, you can, as an elected representative, use some of the funds to promote programs in which you are interested. So which programs are you particularly interested?
I have a number of programs in my district. I started a pantry to feed hungry persons in the district. That's something I'm proud of. I've had before seminars on health, encouraging persons to be healthy. We've had programs for persons who are single mothers. We've had programs, cleanup programs in the district. We've given assistance to persons who have, as you mentioned, medical needs. We just started recently a community garden initiative. I do have funds that go towards my office. I have an office in the district, and I do have funds that go towards that.
Now, if you take the example of some of the initiatives, you've mentioned, for example, seminars on well-being. Does the funding for something like that come entirely from the 125 that you're allocated, or do you work with other agencies and bodies to fund programs like that?
Thus far, most of it has come from my allocation. But in some instances, we appeal to the ministers for assistance for particular programs that fall within their remit.
So one of the points that more than one member of the House of Assembly has made is that when one balances the amount of money that you have to assist with against the level of requests that you will receive during the course of the year, the first is always too small to meet the second.
That is
your experience as well?
That is a fact.
Now, you have therefore an unenviable choice as a member of the House of Assembly and as a district representative as to how to allocate that money.
Prayer.
And you pray for guidance.
We need to rely on God for faith and for direction to make the right choices consistent with our moral and ethical obligations, as well as our goal to help people.
Now, what we have been given, and I think this came through the Honourable Neville Smith, was a document which is headed Guidelines for Processing Assistant Grants.
Yes.
Are you given that as well?
I don't ever remember receiving that, but since these discussions have come up, I've seen a copy of the guidelines, but I must admit, most of the information there I discovered through the process and through speaking with the clerk or the accountant at the House of Assembly. They would tell you this information.
I see. So until you watched the COI's hearings, you didn't realize that a document existed headed Guidelines for Processing Assistance.
I did not, but actually most of it I knew already.
But the information had come to you through your approaching the clerk to the House and asking for information. And
yes, those members who are more experienced, and of course the clerk who's very experienced, share some of this information with you.
Now, one of the things that the guidelines permit is district office expenses relating to rent, staff and operating expenses are allowed up to a maximum of $24,000 per annum. So that's something that you are aware that you can use the sum towards. You can use it to help you with your office in the district.
I wasn't aware of it actually, but I do it anyway. I wasn't aware of that provision. But I have an office.
And you have used some of the funding you're
I've
granted
used some
to support the office.
I've used some of my allocation for my office.
I see. As the evidence is that the process is that you will receive an application as an elected representative. You have to review it and make a decision. If you make a positive decision, it then goes to the clerk to the House of the Assembly to review. And then ultimately it goes to the Treasury Department, who would issue the money, if you like. Yeah. Is that your understanding of how the process works?
Yes. And in some instances, if there's a problem, either the clerk sends it back, and if the Treasury has a problem, the Treasury might send it back. And that happens quite often.
Quite often.
At some point you get a lot better in correcting the mistakes that they point out. And you would hope you wouldn't repeat those mistakes. But, every now and again, there's perhaps maybe a difference in interpretation.
And are some of the mistakes technical? Someone may have missed a date on a document, or they may have not provided a piece of paper that is necessary.
Maybe they didn't sign the form, or in some instances, they didn't provide the right form of documentation.
I see. As well as an application to your district representative, it's right, isn't it, that an applicant could also approach the territorial representatives?
Yes, and there must be some effort to coordinate among us to ensure that persons don't double dip That can happen. But in some instances, you have persons who require help from more than one member. Let's say, for instance, they have a very expensive surgery that they have to do or some medical expense. Multiple members may choose to help that individual.
Can I just deal with the next matter? And that is the operation of Section 67 of the Constitution.
Yeah.
If you have been watching the proceedings, you will appreciate that this is a question that I've put to a number of members. In brief, and we can go to it in more detail if you need it, but Section 67 deals with tenure of seats of members of the House of Assembly, but it does also provide for the circumstances when an elected member may have to vacate his or her seat.
Yes.
One of those circumstances is if, keeping it brief, he or she becomes a party or associated with a contract with the government of the Virgin Islands. And in such circumstances, the House of Assembly, if it appears to the House in the circumstances to be just, may exempt the elected member from vacating his seat.
Yes.
The Commissioner heard from the Honourable Neville Smith, who explained the circumstances in which that had happened to him.
Yes.
So I don't need to ask you about the detail of that. I'm going to ask you first a question, which I'm sure the answer is likely to be no. Is that during your time as a member of the House of Assembly, have you been exempted from vacating your seat?
I haven't had any contracts with the government, so there was no need for me to actually vacate my seat for that particular, or to be exempted from vacating my seat for that purpose.
Now, at least certainly in the case of Honourable Neville Smith, there would have been a motion before the House to exempt him. Can you just assist the Commissioner with this? What information is given to you as a member of the House of Assembly in order to assess such a motion?
Before I answer that, if I could say, in the case of Honourable Smith, that was out of abundance of caution.
That's exactly what he said as well.
Because it's a statutory body.
Yes.
And it wasn't necessarily required. But
that's why
he did
Dr.
it anyway
Wheatley,
for transparency purposes.
But that's why I explained to you a few moments ago that the Honourable Neville Smith had fully explained the circumstances of his motion to the Commission. So there's no need for us to go over that ground again.
Okay.
We understand it.
I didn't watch Honourable Smith's hearing.
If we go back to the point, are you given any assistance or information, or what assistance and information are you given in order to determine a motion such to exempt?
In the case of Honourable Smith, it was for festival and fairs, and that's under my ministry. So I would be aware of the details. And during the course of the debate, if persons had requested of me any information, I surely would have provided it, as it's public funds. It needs to be accounted for.
How does that work then in terms of the debate? If a member raises a question where they want more information, do you give it there and then, or does the debate have to be adjourned in order for you to get the information?
Well, if I have it there and then, I can give it there or then. If I do not have it, I can provide it after. And I think that's standard practice.
Right. And so it's the debate may or the anticipated length of the debate may change depending on whether more information is needed.
Yes, and we can also take a recess if we like, to give time for the information to come if we deem it necessary.
Could you just give me one moment, please, Commissioner, if I may have a moment?
Yes, thank you.
Commissioner, those are my questions. So can I conclude by thanking Dr. Wheatley for coming this afternoon and for the way in which he has given his evidence?
Yes, Dr. Wheatley, can I echo that? Thank you for your time. Thank you for your evidence and the clear way in which you've given it. Mr. Olympitis has taken down notes of one or two documents that you're going to look for.
Yes, which is the report from the committee on the...
And the dates for the committee.
And the dates.
Yes.
So just those 2 points.
your correspondence with the Registrar of Interest that you recently sourced from her?
Yes, I can provide it.
Can I add one thing to that, and I'll explain why?
Okay.
Could you, by noon on Friday, we need it by the end of this week for the reason I'll give in a moment, let us know whether you accept the Section 7 breach in respect of your 2021 return. That's the 3-month point.
Right.
And I'll tell you why. And that's because on Monday afternoon, I'm going to hear submissions on behalf of the Attorney General and the other participants. Those are effectively the non-minister members of the House of Assembly, in respect of the breaches which have been accepted by members and former members over the last few days.
Right.
And it would simply be very helpful to know whether you accept the breach or not. I'm going to have to make a finding, but in fact, in respect of all of the other House of Assembly members, they've simply accepted whatever the breaches are.
Well, just for clarity, I did express that I accepted that we had a breach of
Section
the
3.
March 12th.
Yes.
Yes, and there was just a question of,
Section 7.
you know, whether that day or not, in terms of how you.
It may, in the scheme of world affairs, it may not matter a huge deal,
Right.
but it would simply be easier if we knew exactly what breaches you accepted and what breaches you didn't
I
accept.
can provide that,
Yes.
Commissioner.
That would be very helpful. No doubt with any advice from Mr. Olympitis that you need.
Okay.
Anything else, Mr. Rowett?
No, that's our business for the day. We will resume again tomorrow at 10 with a fresh set of
At
witnesses.
10 o'clock, yes. Thank you again, Dr. Wheatley.
Thank you.